The Appellate Division, First Department, is now in session. Good afternoon and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Leo.
Your Honor, Joseph Nursey here representing Noel Leo.
You have 5 minutes plus 2 for response.
Patricia Curran for Respondent, Your Honor.
You have 5 minutes. Wank versus Estelle West 57th. Appellant.
Sophia Uveda for Appellant.
You have 5 minutes plus 2 for response.
Thank you.
Noah Katz for Respondent.
You have 5 minutes. Matter of MR Children is submitted. Sonera versus Embassy House Eat is submitted. Cambridge Investments versus Prophecy Asset. Appellant.
Frank Franzino for the Appellant, Cambridge, 6 minutes and 2 for response.
That's what you have.
Yeah.
Respondent.
Jason Frank from Morgan Lewis for the Respondent.
You have 8 minutes.
Thank you.
Akhmadova versus Akhmadova. Appellant.
Good afternoon, Your Honor. This is Jason Kislin from Grinberg for Appellant Farkhad Akhmadov.
You have 10 minutes. Respondent.
Your Honor.
This is James Power of Holland and Knight for Respondent Tatiana Akhmadova.
You have 10 minutes. Dejuan versus Grinberg, both cases. Plaintiff Appellant.
Good afternoon, Your Honor. Patrick Petroselli for Plaintiff's Appellants. If possible, could I reserve 2 minutes of my time for rebuttal?
Okay, so you have 8 and 2 then.
Thank you, Your Honor.
Defendant Respondent Grinberg, Mr. Lukes.
Yeah, Stephen Lux from Fishkin Lux, Your Honor.
You have 5 minutes.
Thank you.
Israel Discount Bank, Mr. Graber.
Yeah, good afternoon, Your Honor.
You have 5 minutes. Zayas versus Montefiore Medical Center.
Peter Taglia, Wyron Taglia. May I reserve 1 minute for rebuttal?
So you have 4 and 1 then.
Thank you, Your Honor.
Laura Gentile for Respondent.
You have 5 minutes. Okay, Zayas versus Montefiore Medical Center is going to be called first. People versus Reid, Appellant.
Good afternoon, Your Honor. Stephen Feynman for the Appellant, 4 and 1, please.
You have 4 and 1. Respondent. Is the respondent present?
Alice Wiseman for Respondent.
You have 4 minutes.
Thank you.
Matter of Raymond R. versus Carmen L. is submitted. Cabrera versus 65 West Realty, Park West Realty.
Stephen Score for Appellant. Good afternoon, Your Honor.
3 minutes.
Good afternoon, Your Honor. Seth Weinberg for Respondent.
3 minutes.
Thank you.
Certain Underwriters versus Advanced Transit is submitted. People versus Tancredi is submitted. Fernandez versus 2265 East Tremont is submitted. Pavone versus Samadi. Appellant Samadi, Mr. Ratner?
Yes. Jacqueline Fasano for Dr. Samadi.
Okay, you have 5 and 2.
Thank you.
Appellant Lennox Hill, is it Mr. Simone?
It's Nicholas Tam.
Okay, you have 5 and 2.
Thank you.
Plaintiff Respondent?
Joseph Lanny for the Respondents.
7 minutes.
Thank you, Your Honor.
Brickhouse versus City of New York is submitted. Altman versus Salem Media.
William Sipser for the Appellant.
3 and 1.
Stephen Fuchs for the Respondent.
4 minutes. Chowdhury versus Mikey is submitted. Valencia versus City of New York is submitted. League of Women Voters versus New York State Board of Elections.
Alex DeLisi from Latham & Watkins for Appellant. Your Honor, may I reserve 1 minute?
4 and 1 then. Respondent.
Philip Levitz for the Respondent State Board of Elections.
5 minutes.
Thank you.
So we're calling Zayas versus Montefiore Medical Center first. Justice Gonzalez has recused herself. Justice Gesma has been vouched in. In the event that there's a tie vote, a fifth judge will be vouched in. I remind the attorneys to please keep their microphones muted. I'd also remind you to please not speak over the justices. That's the traditional rule at the appellate division, made even more necessary by doing these arguments virtually. Appellant, please proceed.
Good afternoon. My argument is going to be very succinct. I may be old, I hope I'm not old school, but it's premised on the grounds that if you advance an argument, an excuse, in any context for a default, here we're talking about CPLR 3215, that excuse must be three things. First of all, it must be true. Secondly, it must be reasonable. And third, it should be substantiated in the record. This excuse, as advanced to the lower court and is portrayed on appeal, is none of those things. Counsel ignored my client's non-appearance for 2 years, and their excuse in 3 separate submissions to the lower court was they didn't have complete records. That is not supported by the record. The record shows they were given complete records pre-suit. But let's give them the benefit of the doubt. Let's assume the hospital, for whatever reason, didn't give them complete records. I repeatedly challenged them to say, did you or did you not have the records of the November 2014 admission that pertains to my client? In 3 separate submissions, all they said is, we didn't have complete records. We didn't have complete records. Now, on appeal, we have a 200-page record. On none of those 200 pages will you find any record that tells them, oh, by the way, you forgot about Dr. Vesa. On appeal, counsel says for the first time that they got 800 out of 2,400 pages. Again, they don't address, did you have the record of the November 2014 admission? What did they say they didn't have? They said they didn't have discharge information. I've been doing this a long time. I know discharge summaries, discharge orders, discharge instructions. What is discharge information? We know what it's not. We know it's not the discharge summary because that 5-page summary is contained in the record at pages 87 to 92. It doesn't mention Dr. Vesa. And what we know happened here is very clear. By letter dated August 20, notified plaintiff's counsel, maybe you want to question Dr. Vesa. And by the way, she hasn't appeared. There's something that they also mentioned that I left out of my brief. They mentioned that they had previously requested witness information on numerous occasions. So what are the undisputed proceedings? There were 4 court conferences. There was never a letter to Dr. Vesa, never a letter to her insurance company, never a letter to any of the co-defendants asking, is Dr. Vesa going to appear? And in none of the cases cited by the lower court, none of the cases cited by the plaintiff, can you have no activity within a year and then say, well, we'd like to vacate the vault be like to pursue the action. There has to be some activity in the first year, and here there was none, absolutely none.
Well, counsel, excuse me, this is Justice Weber. Does prejudice or the lack thereof to the defendant play a role in this at all? Does that play any part in the determination?
I don't mention the word prejudice. I don't claim prejudice. And the truth is, you don't know prejudice till you go to try the case. You see what the theory is. So I think, honestly, this case is so weak that it would be hard to claim prejudice because my client was an internist. She had all these specialists who saw the patient during the admission, after the admission. No one suspected a pulmonary embolus.
Okay,
so
does anyone, do any of my colleagues have any further questions? Thank you, Mr. Taglia. Respondent?
Good afternoon, Your Honors. Can you hear me okay?
Yes.
Okay. So I think Justice Weber, really honed in on an important point. There is absolutely no prejudice to having this case heard on the merits, and there's no reason to set aside Judge Silver's exercise of his discretion.
But counsel, this is Justice Gesmer. Yes. I don't know if we even get to prejudice if you don't have a reasonable excuse. As I understood your excuse, it was that you didn't know that Dr. Vesa was important, but you already had 800 pages of records, none of which you supplied to us. Are you claiming that Dr. Veza wasn't mentioned? Well, first of all, you don't attach those 800 records, so we don't know whether you're claiming that Dr. Veza wasn't mentioned. And nobody says that she wasn't mentioned in those 800 pages. So I don't, and also your client, you knew that Dr. Veza was involved because you named her as a defendant. So I don't understand what possible excuse there could be for not doing anything for 2 years after she was served.
Well, okay, I'm sorry, was somebody else speaking?
No, go ahead.
Okay, with respect to our excuse, we do have an 11-month delay, which is a delay.
You have almost 2 years delay, 11 months after the permissible period.
That is true. What happened was, during that time, we recognized 4 defendants that had not answered. We chased them down. We brought them in. We didn't make a motion for default judgment. We wanted the case heard on the merits. We missed Dr. Veza. There's no question about that. And we're very straightforward.
Right, but you haven't explained, you haven't given any good reason why we should excuse the fact that you missed Dr. Veza.
The excuse is that we were very diligent in pursuing the action. We did not abandon any of the action in any way. We realized we didn't have, if we had had the complete chart, we had a certified chart, it was only 600 pages. And
counsel, this is Justice Weber. I don't understand that argument. Why does it matter if the records were certified or not certified if Dr. Veza's name appeared in those records as one of the treating physicians? What does the certification have to do with her name appearing or not appearing?
The certification shows that is why we're relying on what we had, and what we had didn't show that she was a discharge physician. And in fact, Mr. Taglia, discharge is a critical moment in the treatment of a patient.
But it sounds like you don't dispute that those records showed that she was a critic. She was one of the people who was treating plaintiff, right?
She was an admitting, yes, she was an admitting doctor. It was not apparent that she was the discharge physician, which is critical. And that's what
You must have had some basis upon which you named her as a defendant in the case.
Absolutely. She was the admitting doctor. And so she had responsibility. What we didn't realize was how critical she was to the case. And we realized that when we got the complete chart. We had looked to see, and it was very confusing because we couldn't tell who discharged. That's why we sent the letter to the defense counsel saying, give us the discharge doctor, and we didn't have a name. And that's when he said, well, it looks like it's Dr. Veza, but he wasn't sure either at that point. And so yes, it was a mistake. We should have tracked her down. Having said that, mistakes are excusable, and we have lots of case law on that issue included in our brief, and I'll ask the court to look at that. We show the merits, we show our excuse, which there are much more frivolous excuses than what I consider to be a substantial excuse on our part that have been excused by all of the appellate divisions.
Do any of my colleagues have any further questions for counsel? Thank you, Ms. Gentile. Mr. Taglia?
Just in rebuttal, not only did they name Dr. Veza, they alleged that the hospital was vicariously liable for her, and they came up with very specific allegations. And the only thing I would say, this whole idea of discharge is irrelevant. It's not who discharged the patient. It's the workup done during it. During this admission, about 6 days, this patient had numerous tests, numerous consults, and nobody suspected a pulmonary embolus. It's not who discharged, it's not who sent the patient home. It's what tests were done and weren't done. They knew that. They clearly knew that. And to say it's not a frivolous excuse, I think the first question you have to ask, is it a legitimate excuse? Is it an honest excuse? Was it the records, or was it McElwain and Friedman's letter of August 27th that said, by the way, she hasn't appeared, and she may be the one? They said it may have been Dr. Bowers. So I think before we ask if it's frivolous, we have to ask, is it legitimate? And if you're just going to accept law office failure, and I mean this respectfully, then just do away with the requirement. Make it a one issue. Because anyone could say law office failure. Law office failure is when a clerk doesn't document something, or somebody leaves the job. And any excuse postdates to 1 year.
Any other questions for counsel? Thank you both.
I appreciate it.
Thank you. People versus Leo.
Yes, Your Honor. May it please the court, Joseph Nursey representing Noel Leo. Noel Leo was charged in 2 separate indictments with 2 separate burglaries that occurred on different dates with different complainants in different locations and with different witnesses, except that the prosecution called a single police officer who had been involved in the investigation of both cases. The judge who ordered the indictments joined for trial found only one item of evidence admissible in both cases, and that was the clothing that Mr. Lau was wearing when he was arrested in the December 30 incident. The judge in the order, contrary to the request of the prosecution, did not mention allowing any other evidence of any of the 2 transactions.
So the clothes from the 2 incidents
yes.
match up. Is that so? Match.
That's correct. Yes, they match. Yes.
Isn't that a very significant point?
The clothes go to identity, and at a separate trial of the December 27 incident, the prosecution could have introduced the evidence of the clothes that Mr. Lau was wearing when he was arrested on December 30th. The judge's joinder order did not allow any evidence of, in a December 27 case, of what he was doing while wearing those clothes on December 30th. It was just the simple fact of the clothing was all that was allowed by the judge's joinder order.
Identity is an important point. I mean, you haven't conceded identity, and it also is both charges relate to similar sections. Is that not so?
Yeah, no, there's no question that it was. Excuse me, there's no question.
So what's the test on appeal after the consolidation has occurred?
One of the tests on appeal, one of the very significant tests on appeal, is whether there was a disparity in the strength of the evidence in the 2 cases so that trying them together would cause prejudice. And there was a very significant disparity in the evidence in the 2 cases. The first case was solely circumstantial, based on a video that shows him entering the building and leaving the building with no evidence whatsoever presented of what he did inside. And there was only like a period of very few minutes shown in the video. There was 3-hour gap between when the video ended and when the boxes were reported or found to be missing by the complainant in the December 27 case. As to the December 30 case, he was arrested inside of the building, according to the prosecution's evidence, while the transaction was occurring. So there was incredibly significant disparity in the strength of the evidence. And that's been recognized as a grounds for good cause for severing or for not joining cases, even though they are joinable under the Section 2C of the 200.20 of the criminal procedure law. Essentially, the sole reason these cases were joined was because they alleged a violation of the same statutory provision. They were both burglary in the 2nd degree. And that is essentially the only reason they were joined.
Excuse me, I'm sorry, this is Justice Weber. Again, as Justice Friedman stated, they were also joined for purposes of establishing identity. That's what I do not understand with your argument. And then the other thing is, there was a curative instruction given to the jury that they were to separate the 2 incidents. And if they found that the defendant was guilty of one incident, that did not mean that the defendant was guilty of the 2nd incident.
Yes, Your Honor. In every case where indictments are joined, under the standard instruction, the jury's going to be told that they're to consider the evidence separately. That doesn't stop the prejudice from occurring. And it was clear it happened in this case because the only question asked by the jury during deliberation was, could we consider evidence from the December 30 case in finding intent in the December 27 case? So
and the response was no.
I disagree, Your Honor. That was
not the response? Was the response yes?
No, the response was muddled. The judge told the parties that the response was going to be no, But then in instructing the jury, the judge gave an improvised instruction, which at some points indicated that the answer was no, and at other points indicated that
Did
the
you
answer
object
was
to the response? The defendant object to the response?
no. The defense counsel did not object to the response, and that affects two things. It doesn't affect the propriety of the joinder. That was clearly preserved by the defense counsel's answer, written answer to the state's motion to join, which raised essentially everything we're raising here. The other half was, did the counsel appropriately object to the instruction given after that they were joined?
The instruction, which you said was muddled, was that what the judge stated was, because you find intent in one, you cannot then infer intent in the other unless there is evidence to support that. Why is that? Was that not the response?
Then the sentence after that in the instruction, Your Honor, was now the evidence can come from both cases. So that is contrary to what the judge told the parties that he was going to instruct. And I think it was just an inadvertent slip of the tongue, but it nonetheless was answering the jury's question.
The trouble is, your problem is there's no objection at the time. Obviously, defense counsel didn't think that something wrong was happening.
Okay, that was the critical issue for the jury's decision, and they made it clear it was a critical issue because they wrote the note.
Thank you, counsel. Are there any other questions for counsel? Okay, thank you. You have time in response, so let's hear from respondent.
May it please the court, my name is Patricia Kern and I represent the people on this appeal. The court properly consolidated the two indictments here. As Justice Friedman pointed out, and his defendant does not dispute, the two indictments both charge burglary in the second degree under the same statutory provision, and thus were properly joined pursuant to CPL 200.20 subsection 2C. The court properly found that the defendant had failed to show.
I don't know that the dispute is so much that they were not properly joined. That sure, there's the same charge, but that it was prejudicial, so prejudicial that it shouldn't have been joined because one case standing alone was very unlikely to result in conviction. It was the fact that it was joined with a case where he was, so to speak, caught red-handed. Although, I don't know that counsel would concede that, but he's there in the lobby with everything there. So this other case where he is, just you can hardly see the face. There's a 3-hour whatever gap it is between the time he's there and the person actually arrives home, and then overnight before she realizes it. There really is nothing more than the clothing. And he could have been going in there for anything. So that's what he's saying. Okay, same charge, but this is way more prejudicial than it was probative. What's your response to that?
Well, Your Honor, I disagree with the defense characterization of the evidence of the 1227 burglary. First of all, there is direct evidence of the burglary. There's a surveillance film that shows the defendant and his co-defendant, and you can see their faces when they're entering what is obviously that building on 11th Street. They are in that building for 9 minutes. When they go in, the woman co-defendant has a bag stuffed with something, and when she comes out, she has the same bag and she has a package in her hand. The co-op president testified that neither one of these people were tenants, that he didn't know them. The length of time, I know them to be people in the building. The length of time they were in was totally inconsistent with them visiting a friend, but entirely consistent with them committing a larceny inside the building, which of course the people didn't have to prove. They only had to prove that he and his co-defendant intended to commit the crime there. And then the woman who had her packages, the contents of her packages stolen, that was the indication of the larceny because it occurred during the time that the defendants had entered the building. Now, yes, the entire tape did not cover the entire time that the woman was out having dinner. The woman tenant was out having dinner with her friends. But the jury was still entitled to find that these two defendants committed burglary and that they knowingly entered that building with intent to commit a crime therein. Now, yes, in the other burglary, we have the tenants who mistakenly let the defendants into their building, go down, and each of them viewed the defendants hovering over packages or stuffing packages in their bag, depending upon whose testimony you're looking at. But the joinder cases don't require that there be a complete similarity in the evidence. And I should point out, number one, if this case had been severed, it is very likely that a lot of the evidence from the 1230 burglary could have come in. Plus, as Your Honor knows, this defendant was also convicted of burglary in the second degree for a burglary a couple of months before he committed this burglary, just a few streets away on 4th Street. And there was also an indication that he had gone into the East 11th Street building in August of that year following a postman in. So there was plenty of evidence that the people could have presented on the 11th Street burglary had it been tried by itself. So essentially any error that the court made here, and we don't concede that the court did, but it would have been harmless. And I also point out sentences ran concurrent here as well.
Any other questions for counsel? Thank you.
Thank you.
Mr. Nursery.
Okay, I'll start where Respondent finished. Before the trial court, the prosecution tried to get in the evidence of those other charges under Molyneux, and the trial court did not allow them to present that evidence. So that wasn't before the jury. I heard counsel Respondent multiple times saying the word intent. Well, intent is what the prejudice that arises from trying these two cases together. They took a very weak December 27 case and took the December 30 case, and essentially the jury would come to the conclusion, well, he must have been doing the same thing on the 27th that he was doing on the 30th. And that's exactly what they shouldn't have been allowed to do. And that's what their question to the court seemed it was very clear they were doing. And finally, as to the effect of these joinder on both cases, in the Second Department's People versus Martinez case, which is cited in the brief, the court there talked about the improper joinder undermines both cases because of the cumulative effect of the evidence, and this of the two cases. And this court in Forbes, although in Forbes it did find the cases were properly joined, in doing the harmless error analysis, this court referred to the evidence being overwhelming as to both of the joined cases. Not that there was one overwhelming and one not overwhelming. It talked about the evidence being overwhelming as to both of the joined cases. And so the prejudice carries over to both cases because they never should have been joined for a single trial in the first place.
Any other questions for counsel? Thank you. Thank you both. Wank versus Extel West 57th. Appellant may proceed.
Good afternoon, Your Honor. May it please the court, Sophia Uvedas for the appellant, Martone. This case boils down to the proper application of the summary judgment standard. Plaintiff moved for summary judgment on common law negligence against Martone, who was a subcontractor, and needed to show that there was a question of fact that Martone launched a force or instrument of harm per Espinal. If he didn't meet that burden, plain and simple. Plaintiff claims that while he was working on a roof in November of 2013, he was walking backwards, his foot slipped into an uncovered drain hole, causing him to fall. The only defendant left is my client, the roofing subcontractor, whose work was completed almost 2 weeks before the accident.
Counsel, this is Justice Gonzalez. But doesn't the vice president of El Martone testify that El Martone did install the insulation, did cut drain holes? Didn't he acknowledge that it was unsafe to leave a hole exposed, that the holes needed to be filled, and that they were covered with felt, that there should have been bags on top of them or stones, but there was no warning? I don't understand where you're going with this.
Of course. So actually, I was going to say exactly what Your Honor mentioned right now. Martone worked on the roof. They did exactly.
I guess what I'm asking you is, didn't the defendant launch an instrument of harm?
No, by putting just insulation or chemicals on the roof, they didn't launch a force or instrument of harm. Actually, Martone testified that it was their pattern and practice to then cover these holes with 50-pound bag of limestones as a temporary cover until the plumbing contractors would come in and install permanent drain covers.
But do we know in this case that the hole wasn't covered with the bag, because obviously the plaintiff fell into the hole?
Well, no, we know that on the day of the accident, plaintiff says the hole was not covered. He was not there when Martone was working, so there's no testimony that at the time that Martone was on the roof, they did not cover the hole. What he's asking the court to do is he's saying, well, because 2 weeks later, when I had my accident, the hole wasn't covered, I want you to infer that when Martone left, they didn't cover it. But you have this intervening period of time of 1 to 2 weeks, and you have other people, his coworkers, other trades who are on that roof. So by asking you to make that inference, he's actually going against the summary judgment standard, which is that all inferences must be made in favor of the non-moving party. The fact that 1 to 2 weeks later, the bag was not covering the hole doesn't mean that Martone didn't cover it when they were there.
But didn't Martone testify that there were no signs or cones placed to warn others that the bags should not be removed? The bags over the felt covering the holes that were supposed to have limestone in them.
Yes. So Mr. Martone did testify that there was no warning. He testified that—
Isn't that dispositive, counsel?
I would respectfully disagree. Mr. Martone testified that it was black felt with a very heavy white bag, and that there was no problem with that serving as the adequate warning system and fall protection. Similarly,
don't we have testimony from the site safety manager that it was a safety hazard if the bags that were used to cover the holes didn't contain warnings, such as do not remove the covering hole? And then don't we have the admission that my colleague just referred to, saying that there were no warnings? Don't the two of those things add up to their responsibility and failure to live up to that responsibility?
Well, there's two issues. Number one, the site safety manager, Mr. Ross, actually testified differently in different portions of his deposition. So in one part, he says, you know, if it doesn't have this warning, then that would be a concern. But in another part—
how would another team, how would another trade know that they weren't supposed to move it?
Well, like I was saying, Mr. Ross himself says in another portion, I would have no problem if there was no warning. So one, we have competing opinions in the same deposition testimony as Mr. Ross. And number two, the question of the degree of reasonableness or the degree of care. If just placing this contrasting heavy bag was sufficient, or if it also needed to do something like place a warning, that's a jury question. That goes to degree of care.
Counsel, is it a jury?
Our case law is pretty clear that where you have an incident where the individual creates the danger, where the injuries are created or caused by a dangerous condition and is caused or created by, in this case, Martone, then that's it. I mean, that's the Di Maria case, I think it is. So, I mean, it seems kind of clear that El Martone created the reason or created the condition for which an injury resulted, and that's the hole.
Well, they didn't actually, let me back up. One, the hole was still there before they came in and did the roofing, which is a drain hole. But more importantly, they testified that we understand that's a hole. We understand that, you know, this might cause some kind of a problem, which is why we put in temporary protection. But it was temporary protection until the next trade was going to come in and put permanent protection. So the issue isn't, you know, they left the hole and then walked away. They do put in safety, which is this white limestone bag, and Martone testified the bag was there. And here's the very, very important part we haven't gotten to. If you look at the picture immediately after the accident that was taken on plaintiff's phone, there is actually a bag of limestone right next to the hole. So,
any other questions for counsel? Thank you. You have time in response. Respondent?
Yes, thank you. I think the court has touched upon every issue that I have raised on this appeal. I don't think there's any dispute that Martone was responsible for protecting this hole. There's no dispute that there was a hole covered by felt unknown to my client and other workers on this job site, and they chose to set forth this procedure whereby they place a bag on top of it. Hence the court's commentary with respect to the warning signs. That's the importance of the warning as well. In addition to just simply placing the bag, the warning is to advise people not to move the bag, because if you do, now you have a covered hole unknown to workers on the very site, which is the very harm created and the very harm which caused my client to fall through that very hole. What defendants...
Let me ask you about something else. You moved for summary judgment on common law negligence, and you end up with summary judgment on labor law 200. How does that happen?
You're correct, Your Honor. And in reading through the decision, the lower court touched upon means and methods under analysis of labor law 200, and then granted both labor law 200 in plaintiff's favor.
But you didn't even move for that relief.
For labor law 200, Your Honor? Correct.
Right.
I did not. So the court did search the record. I did in my papers request any other form of relief. The court took it upon itself to search the record and did grant 200. I will say that the court, in my opinion, also correctly found 200 insofar as, again, there being no dispute that the defendant, Martone, was responsible and in fact created this condition. Although I am not here telling the court that Martone directed my client in the very...
What is the precise negligence which you say gets you to summary judgment? What was the improper action what was the negligent action by the defendant, by Martone?
Sure. So we know it was their duty to place the bag and cover the hole and protect it. We have a photograph showing an uncovered hole. We have a photograph showing a bag with no warning sign saying do not remove, so that other workers wouldn't touch this. That duty falls only on Martone, and that's where the record is quite clear. This is all of Martone's work and no one else on this job site. The fact that the hole is uncovered, you have an unmarked bag with no warning sign, as other people on this job site responsible for site safety spoke to, the need for the warning sign for this very reason, so that it does not get moved. That's the negligence, Judge, and it falls squarely on the lap of Martone.
Any other questions for counsel? Thank you. Appellant?
Yes, Your Honor. Just very briefly, I would like to address something that the respondent said, actually two small issues. Number one, he said there's two theories when Justice Friedman asked him, what is your theory of negligence? One, he seems to briefly say you didn't place the bag. And as I discussed, the circumstantial evidence clearly raised a question of fact, because our client says, no, it was part of our practice to place the bag. And there is the bag in the post-accident pictures right next to the hole. So I think there's more than enough questions of fact as to whether we actually did place the bag. Now, whether that bag was sufficient or it needed additional warning signs, well, again, that is a jury question. And we cite quite a few cases from the Court of Appeals down, all saying degree of reasonableness is a question of fact for the jury because it goes to breach. And we spoke about Mr. Ross, and he says, well, Mr. Ross said, you know, you should have placed a warning. There is a portion of the testimony that we cite in our reply brief, and it's in the record 418. And they asked him, was there any requirement on the site that when a hole was cut in the insulation and the felt was placed on it, and the bag of stone was placed on the hole, that any type of sign be placed around that area, indicating or to warn or to tell people that there is a hole beneath the stone? And Mr. Ross answered, no, there was no requirement. So they're trying to cherry pick portions of that testimony. To the extent that Mr. Ross says there's no requirement, I had no safety concerns with the way I knew how Martone did it, and I had no safety concerns with how they operated and protected the hole. And another portion of its testimony says, well, if there was no warning. Well, those are conflicting issues. So Mr. Ross himself gives conflicting answers, and a jury should be able to decide which of those to believe. We're not asking for summary judgment. We're not asking for dismissal. We're just asking for a question of fact on common law negligence. This is not a labor law claim. The labor law really went to boil down to the state actor issue. I apologize. The owner issue. Are we statutory owner? And when we moved on that point, plaintiff didn't even oppose it. So with all due respect, they've abandoned that claim. And if you do look at the cases on statutory owner, the subcontractor Martone did not meet that definition.
Any other questions? Thank you, counsel. Thank you both.
Thank you.
Cambridge Investments versus Prophecy Asset. Appellant may proceed.
Good afternoon, Your Honors. Can you hear me?
Yes.
My name is Frank Franzino, and I represent Cambridge, which is an investment advisor. Cambridge was entered into a contract, an account investment advisory agreement with the Defendant Prophecy. The purpose of the agreement was clear. Prophecy would deposit an investment account up to $30 million. My client would deposit $3 million. My client would have sole discretion under the agreement. Front page of the agreement to invest and reinvest. What happened was there was a market glitch.
Is your basic complaint, the underlying reason for this lawsuit, is that you are hoping that Prophecy would allow you to invest more money, to have a greater amount than originally contemplated, and instead they cut back on what you could invest?
No, Your Honor. We wanted to invest more money, but what they did was that they took and liquidated the investment account, and as a result, we had to guarantee that investment account, which really cost us a lot of money.
Counselor, your relationship, this aspect of it is covered by two documents. It's Section 2A and Schedule A to the agreement. And when you say what you just said, how does that tie into what Schedule A says at page 79 of the record? Allocations may be increased as mutually agreed upon by both parties or reduced at the sole discretion of Prophecy.
Let's look at the record 78, which sets forth the agreement. And it says that $30 million is to be put into an investment account by Prophecy. $3 million is supposed to be put into a deposit account by my people. And my people would guarantee with these $3 million any losses. Not a bad deal.
Are you answering the question?
Yes, I'm about to.
Because the documents do say that the allocations may be reduced at the defendant's sole discretion.
So what we're saying is that the only rationale, when you look at the agreement as a whole, when you look at 2A, which gives us the right under the agreement to invest, that the only rational interpretation of this clause in the addendum is that it would reduce the cash allocation of the $30 million. Once we were investing, my client had the expertise. And so under 2A, my client had the sole discretion how to invest. My client put its skin in this case. It put $3 million up, which it lost most of.
Well, 2A does not give you unlimited discretion. I mean, it says subject to the right of Prophecy to monitor and immediately exercise discretion and terminate advisor's discretion in the event that. Now, I understand that this comes down to the provision about violation of fiduciary duty and whether or not they can show that there's been a failure to uphold fiduciary duties. But you're still left with Section A, which gives sole discretion of prophecy. I mean, this agreement doesn't seem to have given you, when it comes down to eliminating your right to invest and how much you're going to invest, it doesn't really seem to give you a whole lot of rights. I mean, how do you get past Schedule A? What Schedule A says, sole discretion to prophecy.
If you take that approach, Your Honor, what does 2A mean? My learned co-counsel in his brief says it's an alternative. But how am I protected by an alternative? Is that what I bargained for? An alternative?
Well, you agreed to sole discretion in Schedule A, and you did bargain for Schedule A and agreed to it.
But Schedule A can only mean, which would make sense, especially since we don't have discovery. And we're talking about these ephemeral things. But Schedule A can only mean allocation of the funds in the investment account. Once the funds are turned into securities, doesn't Section 2A, which gives my client sole discretion, come into be? That is the issue that Judge Maisley raised. Why can prophecy call the trading desk up and do this? And for the first time, we heard an oral argument by learned counsel that, well, under 2A, there was a breach of the fiduciary duties without any papers whatsoever put in. So what we're saying is, Judge, we have to have a chance to have some discovery in this case.
What did the agreement say about the right to terminate the agreement?
Both parties had the right to terminate, but that's under Section, I think, 9 of the agreement. But that was not done at the time that prophecy came in and usurped our authority and liquidated the accounts.
Counsel, you were talking about the amount of money that your client put into this investment, so to speak, and that was $3 million.
Right.
But the other side put in $30 million, and putting in $30 million meant that they retained some control over their dollars. And that's what Schedule A is referring to. I mean, if the parties intended to reach the agreement that you're speaking of, it would have been put into writing, wouldn't it?
Well, Your Honor, if 2A comes into play, they have to prove that they had a bona fide belief to protect their fiduciary duties. What we're saying is, Judge, at a motion to dismiss stage, there's nothing before the court.
You're saying they haven't proved that. They haven't presented evidence supporting that. Any other questions for counsel?
Yeah, that's what we need some discovery on, to find out what evidence they have to see if it's bona fide. Simple.
Do my colleagues have any further questions for counsel? Thank you.
Thank you very much.
You have time in response, so we'll hear from you again. Respondent.
Good afternoon. Jason Frank from Morgan, Lewis, and Bacchius on behalf of Prophecy Asset Management. Cambridge seeks to make complicated what's quite simple. In February 2018, Cambridge was managing a
So what does the agreement mean? What does 2A mean when it says that Cambridge has sole investment discretion? What is that over the assets in the investment account? What is that talking about? How does that play out here?
That provision provides Cambridge with the ability to trade the assets in the account. But that very provision says that Cambridge can't withdraw any assets from the account. That right, the ability to take back Prophecy's assets, was retained in Schedule A. Schedule A provides that Prophecy can reduce in its sole discretion the amount in the investment account. So once it reduces that amount, Cambridge no longer has discretion to trade those funds. And to read this clause the way that Cambridge asks you to read it, reads out of the agreement the phrase sole discretion.
Let me ask you this. What does 2AC mean when it says Prophecy believes that it is necessary to do so in order to uphold its fiduciary duties to its clients under applicable law? When does that come into effect? When does that come into control this?
So if Prophecy decides not to reduce the entire allocation, but rather merely it leaves the allocation with Cambridge and decides to terminate Cambridge's discretion for all or part of the account for a period of time or forever, then that provision comes into play. But if Prophecy decides to reduce the allocation, that is to remove the money from the account, it's under Schedule A. It's only if it leaves the money there and doesn't reduce it that 2A comes into play.
But if it wants to take it out, it could just take it out under Schedule A.
That's correct. And so, Your Honors, one of the interesting things about this case is how very different the complaint is from what we've seen on appeal. In the complaint below, we see that Cambridge complained about what Justice Friedman noted at the outset. Plaintiff complained about a decision to reduce the allocation. Plaintiff complained about a refusal to increase the allocation. Those claims that are in the complaint run head into Schedule A. Schedule A makes it crystal clear that Prophecy had sole discretion to reduce. Prophecy could, by agreement, increase, but wasn't required to increase. And so Schedule A ends this case, and Justice Massey was correct to rely upon it. Now, it's controlling law that a party cannot breach a contract by exercising its contractual rights. Similarly, it can't breach the implied covenant of good faith and fair dealing to exercise its contractual rights. So this case is quite simple in view of Schedule A, and it appropriately came to a swift end. Now, because it's so simple and because it came to a quick end, Cambridge has asserted a number of other arguments. Cambridge has based arguments on a so-called 10-to-1 ratio, a minimum requirement that if it deposited a certain amount of funds in its deposit account, that Prophecy was required to give it a certain amount of money in the investment account. That argument suffers from many flaws. There's no such requirement in the agreement. Schedule A provides Prophecy with the discretion we discussed. Third, the only provision that deals with the level between these two accounts gives Prophecy sole discretion to determine whether it's comfortable with the level of security and to either require additional security or allow Cambridge to reduce exposure. And finally, Cambridge's arguments based on parole evidence. And the court can't look to parole evidence given the lack of contractual ambiguity on the issue and an integration clause. The fact is, even if the court looked at the parole evidence, it actually doesn't even help Cambridge. So Cambridge tries to create this confusion with 2A, but 2A, as I've explained, really doesn't create a problem. Cambridge had authority to trade in the account, but money that comes out of the account, Cambridge doesn't have the authority to trade that. And if it did, it would make no sense. It would destroy the very meaning of that provision in Schedule A. If Prophecy can, what does it mean to reduce the allocation, but Cambridge can still trade? You heard here, and we heard this for the first time on appeal, an interpretation that the clause applied only to cash. But that makes no sense. So $30 million is given to trade, and as soon as they invest.
Counsel,
yes.
I'm going to ask you a question with respect to 2A.
Sure.
In your view, did your client terminate plaintiff's discretion?
In my view, we removed the money from the account pursuant to Schedule A, and as a result, plaintiff no longer had discretion. I believe that my client had authority under both Schedule A and 2A to do what it did. But as I said to the court below, we don't need to get to the issues raised by paragraph 2A. The fact of the matter is they had sole discretion to reduce the allocation. They did so. Once the money was no longer part of the allocation, my client, all the rights to trade reverted to Prophecy. And there were no rights that Cambridge had to trade.
Any further questions for counsel? Thank you.
Thank you.
Your Honor, counsel at oral argument the first time said these two clauses are linked. And I think he's right. The first clause, 2A, has to deal with our investments. The second clause under the exhibit has to deal with the cash that's in the account. Otherwise, when you read the document as a whole, what is the purpose of 2A? Why is 2A in there if Ipsy Dixit, by one stroke, the thing is over? Under 2A, once the cash is put into securities, the prophecy has all the protection if it goes through A, B, and C of 2A, fiduciary duty, so on and so forth, which was never put forth by prophecy in this motion. So what we're saying is, let us look and see if prophecy really was able under 2A to usurp my client's discretion. Otherwise, this whole contract, you're just reading out 2A, and that's our problem, without having discovery. That's it. Thank you, judges.
Thank you. Thank you both. Akhmadova versus Akhmadova.
Yes, Your Honor. This is Jason Kislin for Appellant Farkad Akhmadov. If it pleases the court, may I reserve 1 minute of my time for rebuttal, please?
Yes.
Thank you. This matter stems from a very contentious divorce between plaintiff Appellate, a UK citizen, and appellant defendant Farkad Akhmadov, a citizen of Azerbaijan.
So let me see if I understand what's transpiring here. There is, according to an affidavit submitted by counsel who represented the defendant in a Russian divorce. There was a Russian divorce in 2000. The records, the index reflects that there was such a proceeding, although the divorce itself is not found in the records. There's then for want of perhaps some more, whatever the United Kingdom word for it, there is a proceeding in the United Kingdom dealing with divorce. There's a divorce there, there's a distribution of property, etc. And the plaintiff gets a judgment, which he now seeks to take this foreign judgment and docketed, have it declared a valid judgment to the state of New York. So that's basically what we're talking about. So there is, you have to bring a proceeding in order to get that done. Unlike if you have a judgment in a sister state of New York, you could just docket that judgment in New York. When you're dealing with a foreign judgment, you actually have to bring a proceeding here to have that recognized. So that proceeding is brought, and the defendant says, look, you shouldn't be following this English judgment because there is an issue about the English judgment in that it decided the divorce action, but there was a previous divorce. And then the question becomes whether the court can just go to that and regard that as frivolous, or in order for the court to make a decision about that issue, Supreme Court, New York State Supreme Court has to first decide, is there jurisdiction in New York? Is there some basis for New York to make an adjudication about the defendant, whether it's in personam jurisdiction or in rem jurisdiction? And what happened here is that the court made this determination without making any decision about whether there was a jurisdictional basis for New York to exercise jurisdiction over the defendant.
That is exactly right, Your Honor.
Well, counsel, we have to do a little bit, if we just go back a little bit, when we look at the CPLR, I want to ask you, why do you think the court was wrong in its decision?
Well, I think the court was wrong
to decide, let me just finish that, I guess I should, decide that there was no need for personal jurisdiction to be found before, that essentially that our acts were going to be ministerial. So based on the facts, why wasn't the court correct in that?
Well, I think I don't think the court was correct because defenses were raised, and in Albania, which is a case that was decided by this court in 2018, the court says when you're trying to when someone comes to recognize a foreign judgment, the court can do that even where there's not jurisdiction, except when a defense to recognition is raised. And once a defense is raised, well, now the court is tasked with making a decision.
Where is the defense? Where is the defense that was raised? If you're talking about the divorce, are you talking about the divorce?
There were two defenses raised, Your Honor. One was the prior judgment from Russia, and a prior inconsistent judgment under CPLR.
Okay, so
you're looking to the discretionary grounds. You're looking to the discretionary grounds under 5304. And so the question is, with regard to the Russian judgment, these are lawyers, presumably, and we're supposed to be considering a judgment where there's no judgment, nothing attached, just an affidavit that says something, that says, yeah, there's a judgment, or there was a proceeding.
Yes, Your Honor. The affidavit, which was made on personal...
How does that raise a triable issue of fact, that mere statement in the affidavit?
Well, there's two things, Your Honor. One is yes, it is in nature of a summary judgment proceeding, but the case in Albania, the Albania court says you just have to raise a colorable, non-frivolous
Counsel,
defense.
how is this colorable and non-frivolous? The affidavit simply says, I am a lawyer, my firm represents, I'm a lawyer in Russia, my firm represents the husband in this case in connection with the Russian divorce proceeding, which proceedings are ongoing. Now, in a normal situation, you look at this and you say, okay, what's the name of the case? What's the index number? What stage of the proceedings are we at? There's no information here. This is hearsay. This is a very defective affirmation by way of a submission for a motion for summary judgment. This would not be accepted from an American lawyer. Why should it be accepted from a Russian lawyer?
Well, respectfully, Your Honor, we believe it does raise issues of fact. It does talk specifically about the courts where the initial Russian divorce judgment was entered in 2000. It then goes into detail about how the plaintiff made an application to annul that divorce judgment in 2004, unbeknownst to Mr. Akhmadova.
So where's the documentation from the court that corroborates the affidavit? It's not here, is it?
Well, that was part of the problem. That was one of the problems, Your Honor, which is that the documentation was not in the court file.
And didn't the UK court consider this and say that that one of the documents was forged in this case? Wasn't all of this raised overseas?
I do believe that the Russian judgment was raised in the context of the UK court. Absolutely, I do believe it was. But it was also raised here as a discretionary grounds where this court could say there's a prior judgment in Russia, and I'm going to exercise my discretion.
The question isn't whether you're going to win
Doesn't there need to be
on
valid
this
evidence
affidavit. The question isn't whether you're going to win on this affidavit. The question is whether you've asserted enough to be entitled to have a determination made by Supreme Court, whether there is either personal or in rem jurisdiction. It doesn't necessarily have to be personal jurisdiction, but there has to be at least in rem jurisdiction before New York State Supreme Court is going to make an adjudication about you in terms of recognizing this foreign judgment. Granted, this affidavit that you've submitted may not be the most powerful document. Certainly it's not, but it does make the point that the index in the Meshkansky court does reflect that there was a divorce proceeding, and an attorney has stated this under oath, and this is the sort of document which would normally be considered on a motion of this type, is it not?
Yes, Judge, I believe that it is, and I do believe it creates at least an issue of fact. And at the end of the day, this may not carry the day. The judge could decide, you know what, I'm not going to exercise my discretion because I don't believe this affidavit, and I'm making a credibility determination that I don't think this affidavit is valid. But it can't make that decision unless and until it exercises jurisdiction over the defendant, because by doing that, by making a substantive decision, and Albania says that exercising judicial discretion is a substantive decision.
Let me ask you a different question, counsel, which is to say, where in 5304 of the CPLR, where it lists the grounds for non-recognition of a foreign judgment, does it say anything about in personam or in rem jurisdiction in New York State? Because there's a lot of grounds here. There's 2 under 5304A and there's 8 under 5304B, but nothing is raised about in rem or in personam jurisdiction, right?
Jurisdictional requirement, Your Honor, comes from Albania and from the due process requirement. And what Albania says
Which is contrary to the Abu Dhabi case, right?
It is contrary to the Abu Dhabi case, but every case after Albania has followed the same exact law. So there is not one case.
Isn't it sort of basic that before New York State is making a substantive determination about a litigant in front of the court, that it have at least in rem jurisdiction of that person? And the significance of making this determination is once New York State recognizes this judgment, you could take that judgment to any state in the union and docket it.
We completely agree with that, Your Honor, and it is consistent with the longstanding principle that a court in New York cannot render a judgment against a party that it does not have jurisdiction over. And that is exactly what happens here.
But that's a broad statement that you're making without referring to we're going over the same thing, but of course you can't do something without jurisdiction. But the whole conversation and issue that we're discussing here is whether or not it's ministerial and whether or not that's, so let's not say we can't do this without jurisdiction. That's kind of basic. I think we get that. But there is a little bit more to this. And I think, if anything, there's no question that you don't, under 5304, 5304A, you don't have a leg to stand on there. 5304B, the question is, what kind of affidavit is this? Do we have to take that as a basis of raising a triable issue of fact? That's really the question. What is, anyway.
I understand. I appreciate
that. Counsel, you've reserved time. Let's hear from the respondent.
Yes, panel. This is James Power. So I think
counsel is making a determination that this affidavit from Irina Skaglova is worthy of no consideration. Is that a ministerial action?
Well, this court in Albania has said that there is a minimum amount of steps that have to be taken by the court to establish whether a defense is frivolous or non-frivolous. So by the very definition and the rule outlaid in Albania, which we believe Judge James followed to the T, and we believe that we have met, is that yes, if a defendant, otherwise you're creating an exception which swallows the rule. If we believe that any affidavit,
counsel, certainly you agree.
Or not truthful, can create an issue.
Counsel, certainly you agree with the idea that before New York State makes a decision about a party, that generally speaking, there should be jurisdiction, at least in rem jurisdiction, over that party.
Yeah, we do not disagree with the finding of Albania as it clarified the Abu Dhabi finding. We are well within the finding here. The question to be asked is that, and because again, it's pretty clear that you do not need jurisdiction in rem or in personam to do the ministerial act of recognizing a judgment. The question then becomes is, if a defendant raises a non-frivolous or colorable defense, here defendant is saying, I am going to do an affidavit, self-serving affidavit of someone who says, I believe there might be a foreign judgment. You need to believe me. I can't produce the judgment. The issue has already been litigated in London, and the very documents that rely upon have been found to be fraud.
Ms. Skaglova says in her affidavit, despite that, a record of the 2000 proceeding remained in the alphabetical index of cases for the Suzinski court. So it's not just saying, oh, I believe there's a judgment. There is pointing to something that, in fact, there was a case.
Well, whether there's a case is irrelevant.
That's not contradicted, is it?
Well, we believe it is, because just because you have a case under Article CPLR 5304, there is a statutory discretionary factors. It is not, and that's 5304.
Do we have any? Counsel, this is Justice Gonzalez. Yeah. Do we have any indication from the Russian court that this is true? Do we have anything that says that there's documents that are missing? Is there anything? Because I looked in the record. I didn't find anything.
No, again, there is nothing. There is, I mean, if defendants, we believe that the appellant had taken steps in Russia to try to establish documents, and those steps were not successful because there is no judgment. There is no conflicting judgment.
What did the 2004 order provide? The 2004 order of the Russian court provide?
How do we know?
Yeah, exactly. In other words, this is that would be pure speculation.
Counsel, Ms. Pavlova says that there's a 2004 order annulling the 2000 divorce decree. Are you contending that 2004 order doesn't exist?
I don't. It would be inappropriate to speculate as to what is going on in Russia at this point in time. The requirement for defendant to meet his obligation to provide a colorable or non-frivolous defense on a discretionary factor is to produce a conflicting judgment, not a hearsay affidavit.
Is an affidavit from an attorney, from a foreign attorney, is that not the sort of document that now the court may decide it doesn't want to credit it or whatever, but is that a document which would not be considered on a motion of this type?
Yeah, absolutely not. That would be opening a slippery slope. The standard is clear, and it says it in the statute. A judgment conflicts with another final and conclusive judgment.
The slippery slope that you're referring to is only whether the court has to make a determination whether or not there is some sort of jurisdiction over the litigant against whom it's about to impose a judgment.
No, I think the determination has to be that it's the appellant's burden here, the defendant, to produce a conflicting judgment as part of the non-discretionary grounds. If the defendant cannot produce a judgment, it cannot be supplanted by simply producing an affidavit.
Let me ask you this. What is the underlying justification for the Abu Dhabi resolution of its appeal? When you're talking about recognizing a foreign judgment, it's not like you're talking about taking a judgment from one state and docketing it in another state. But when you're talking about taking a foreign judgment and giving it recognition in New York State, which gives it the force of a judgment in all 50 states of the Union, why shouldn't there be a need to show before that sort of a determination is made to impose that sort of liability upon someone? Why shouldn't there be a need to show that New York has jurisdiction over that entity, over that person?
Well, I think what you're getting into now
what's the justification for dispensing with that sort of basic due process?
Well, I think that's clearly laid out in the Albania BEG case and Abu Dhabi. It's pretty clear that you do not need for the ministerial act any personal or in rem jurisdiction to recognize to ministerially recognize a foreign judgment. So the question
it seems like the legislature, I mean, the CPLR 5304B specifically says, and the judgment conflicts with another final and conclusive judgment.
Yes.
We don't have any evidence that there is another final and conclusive judgment. If anything, this seems to show the absence on this record and this information of another final and conclusive judgment. It's not here. And if we're talking about a lawyer who is submitting an affidavit saying that there's something that exists, it begs the question, well, where is it? Where is a document, some sealed document, something to reflect what she says about the number and the way it's listed? It's absent on this record.
Yes, I agree. I would also like to make an important point as to the plain meaning of 5304B5, which is a conflicting final and conclusive judgment. This is sort of a misdirection, we believe, is that even assuming one exists, and we don't concede that there is a conflicting Russian divorce, which we say is non-existent, and we're not going to take the word of an affidavit of a foreign lawyer. But certainly that is not what we're seeking to recognize here. What we're seeking to recognize is not the divorce proceeding, whether it happened in Russia or England, but a financial remedy hearing which distributes assets pursuant to the UK court proceeding. That is what's being recognized here. So it's not even as if the appellant offers up a conflicting or says one exists, a conflicting Russian final conclusive judgment allocating the assets between the two parties. So that is another important distinction. So they are so far removed from what is required under 5304B5 that, it begs the question, if you were to accept an affidavit under this circumstance, you are ipso facto, de facto overruling both Albania and Abu Dhabi, because then you are essentially creating that everything is that anytime somebody just alleges there's another conflicting judgment without producing it, that is again the slippery slope in the Pandora's box, which I don't believe that Albania or Abu Dhabi.
It's not overruling Albania bag. Any other questions? Thank you, counsel.
Thank you.
Appellant. Thank you. Just very quickly, this is not just any document. It's an affidavit made on personal knowledge, which courts on summary judgment review all the time and make a determination as whether they raise a triable issue of fact. And here, this affidavit does raise an issue of fact as to whether or not there is a conflicting judgment, a prior judgment of divorce. And the question is, what happens next? And it's not whether the judgment gets entered or not. It's whether the court can exercise its discretion and disregard the affidavit before it exercises or before it determines whether or not it has jurisdiction over the defendant. And here, the lower court refused to determine whether it has jurisdiction. It said, I don't have to do that. And I think if you look at the language that the court...
You're asking us, counsel, to accord unusual power to an attorney's affirmation. This isn't an attorney's affirmation even, it's an affidavit. But you're asking us to absolutely overrule everything that's been said about attorneys' affirmations, which is that they are advocacy documents and nothing more. They don't prove anything.
Well, that's when the attorney is of record in the case. I would agree with that. But here, counsel, this is a factual.
Counsel, we don't even know that this attorney is admitted in New York. This is not submitted as an attorney's affirmation. It's submitted as an affidavit by someone who claims to have knowledge of certain things. It's not like an affirmation. It's not like an affirmation on a summary judgment motion. This is submitted as evidence of what the Russian records reflect. Now, I am not going to tell you it's compelling evidence of what the Russian records reflect, but it does say that there was a 2000 divorce. The alphabetical index reflects it, and it claims that there was then a subsequent 2004 ruling in Moscow annulling that divorce.
I have a question.
Is there anything submitted which contradicts these claims in the case here?
No, there was nothing submitted to contradict the claims. And I would just point to one more thing.
Excuse me, counsel. How do we know that she's a lawyer?
Because she represents that she is with the firm of Akhmadova.
No. She doesn't say I represent. My firm, Schlekoff and Partners, represents. How do we know she's not a paralegal?
She represents that she's fully familiar with the facts and circumstances.
Right, but a paralegal could be fully familiar, right?
That's true. But the point is that this is not...
We don't know that she's a lawyer either.
Your Honor, what we know is that she's fully familiar with the facts, and this is a factual affidavit. This is not an attorney affidavit that's trying to argue something.
This is not. Counsel, this is not a New York lawyer submitting an affirmation. This is an affidavit from someone in Moscow.
Correct. That's submitting factual information relating to the prior Russian judgment. And the one thing I would just say in closing is, if you look at the language that the lower court used, it says that the defendant did not meet its burden of persuading the court that it should refuse recognition. That's not the question. The question is, did the defendant raise a colorable, non-frivolous defense that would require the court to determine whether it had jurisdiction over the defendant before it reached the question of whether or not it was persuaded to exercise its discretion? And we believe that this is Albania. It is a defense was raised. You have to establish jurisdiction over the defendant before you do anything else.
And then you can do whatever you decide you want to do with the defense.
Yes, Your Honor. Thank you.
Thank you both. Dejuan versus Grinberg. Appellant, please proceed.
Good afternoon, and may it please the court. Patrick Petrucelli from Strzok & Levan on behalf of plaintiffs' appellants. Just again, for the record, I would like to reserve 2 minutes of my time for rebuttal. I'm going to be addressing 4 points today, time permitting. First, I'm going to explain how, under the mandatory New York forum selection clauses that were applicable to the accounts where the assets were held prior to their embezzlement, applied to the plaintiff's claims against Mr. Grinberg. Second, I'm going to explain how, even under a traditional inconvenient forum analysis, plaintiff's claims against Mr. Grinberg have a substantial nexus to New York, and Mr. Grinberg failed to satisfy his heavy burden of overcoming their choice of forum. Third, with respect to the claims against Israel Discount Bank, I'm going to explain how those claims are all viable and were not rendered moot. And finally, time permitting, I will address the separate appeal with respect to renewal. Turning first to the forum selection clauses. The accounts prior to their embezzlement, or the assets prior to their embezzlement, were each held in accounts maintained in New York by Israel Discount Bank that were all governed by agreements that contained exclusive New York forum selection clauses and choice of law provisions. Those provisions applied to all claims relating to or arising from the agreements. Those are two separate requirements or two separate prongs for the applicability of the forum selection clauses.
Who are these, counsel? Who are these agreements between?
They are between the corporations, Aramouse and Budapest, two Bahamian corporations, signed by Mr. Grinberg in his corporate capacity, and the bank.
So was he a party to the agreement?
He was a party in his official capacity on behalf of Aramouse and Budapest, and under the closely related doctrine that's been applied by this court, by the Second Circuit, in a number of cases cited in our brief on page 27 to 28, because he is closely related to the corporation, because he's a shareholder and officer of the corporation, and because he signed the agreements in his official capacity on behalf of the corporations, personal claims against him can be governed by a forum selection clause. Turning back to the actual phrases that were used, relating to and arising from, I think it's very important that the court gives both of those terms their own independent plain meanings, using plain everyday dictionary definitions, which courts in this court and others have adopted. For example, relating to has been consistently held to mean connected by reason of an established or discoverable relation. And here we have multiple established connections between the claims plaintiffs brought against Mr. Grinberg and the account agreements. The corporate assets were held in the accounts immediately prior to their embezzlements. All aspects of those accounts were governed by the agreements, including the manner in which the assets held in the accounts could be transferred. Mr. Rosenthal, again, was a corporate signatory to the account agreements. He used his appearance of authority as a corporate signatory to those agreements to authorize the illegitimate transfers, and the account agreements themselves supply the necessary predicate for all of plaintiffs' claims, the underlying ownership by the corporations of the assets. I want to talk quickly about arising from.
Counsel, aren't these issues before the Bahamian court?
They are not, Your Honor, and that's a very important point. The Bahamian court, taking a step back, after plaintiffs initiated this action against Mr. Grinberg and against Israel Discount Bank, Mr. Grinberg filed what is essentially a declaratory judgment action in the Bahamian court, asking that the Bahamian court order that the two individual plaintiffs are not shareholders of the corporation, but instead they hold their shares as part of a constructive trust for Mr. Grinberg. The Bahamian court is not going to be adjudicating whether Mr. Grinberg embezzled the corporate assets, whether he committed any of the torts that are alleged in the complaint. And so in the event that our clients are found to be, in fact, shareholders of the corporations in the Bahamian court, first of all, Mr. Grinberg would need to get that order.
But they required him to return the funds from his personal account to the corporate account, right?
So I think that's a separate issue, which relates to the forum nonconvenience point, which I'm happy to turn to now, because what happened was the New York court entered a preliminary injunction restraining Mr. Grinberg from further transferring the assets from his personal account. The Bahamian court then asked that Mr. Grinberg return all of the assets back to the corporate accounts and essentially replace the New York preliminary injunction. The parties entered into one stipulation that said that they were going to jointly issue instructions to Israel Discount Bank to effectuate the transfer required by the Bahamian order. They never entered into the second agreement, which actually would have effectuated the transfer. For over a year, Mr. Grinberg maintained possession of all of the assets within his account, his personal account at IDB. And
don't you have to go to the Bahamian court and, I don't know if they have contempt, but seek a contempt finding? Not to suggest anything.
There have been attempts in the Bahamian court to seek contempt findings on both sides here, but I think that's a completely separate issue from whether or not New York is an inconvenient forum to adjudicate plaintiff's tort-based claims against Mr. Grinberg. When you're talking about a traditional, of course, we believe that the forum selection clauses in the agreement applies for the reasons I've already stated, because the claims all relate to the account agreements. And so we think if that's the case, if we're right on that, we think that's the end of the matter. But if this court were to conduct a traditional forum nonconvenience analysis, it still needs to consider whether or not plaintiff's actual claims have a substantial connection, a substantial nexus to New York, such that Mr. Grinberg has satisfied what the Court of Appeals has described as his heavy burden of overcoming plaintiff's choice of forum. And here we think there undisputably is a substantial nexus.
So what would the nexus be to New York?
The claims involve New York banks. They involve the underlying assets were held in a New York bank. They were held by the corporations in New York banks. They were transferred to a New York bank.
Your clients transacted business in a bank in, is it New Mexico?
We had a conversation with a representative from Israel Discount Bank in Mexico, but Mr. Grinberg held, on behalf of these corporations, the corporations themselves held assets in a New York bank.
Did Grinberg ever come to New York to transact any business at this bank?
Not to my knowledge, but he did engage in conduct in New York. He effectuated the transaction that occurred in New York. This case also involves consideration of documents held in New York, not only by Israel Discount Bank, but by other New York banks, such as JP Morgan, Bank Leumi, Morgan Stanley. The day after Mr. Grinberg...
Counsel, any other questions for counsel? You have time in response. Let's hear from the respondents.
Thank you, Your Honor. Can you hear me okay?
Yes.
May it please the court, Stephen Lux from Fishkin Lux on behalf of Respondent Grinberg. Your Honors, the trial court properly went through the relevant factors for what counsel refers to as the traditional forum nonconvenience analysis. It properly assessed and concluded that that all parties except nominal stakeholder IDB were foreign, that all the documents and witnesses related to the litigation against Mr. Rosenthal were out, that plaintiffs, Dejuan and Masri, allegedly suffered damages in Mexico, and plaintiffs Judapest and Aramaus allegedly suffered damages in the Bahamas, not New York.
Did your client ever come to New York and actually transact any business?
No, Your Honor. The at-issue transaction, which was lawful under Bahamian law, was conducted from Mexico City, and did
Counsel,
not.
Are there 10 bank accounts at the Israel? Sorry, are there 10 bank accounts in New York?
Well, they are labeled. I don't know if there are 10, Your Honor. I think that there were
a number
4. I think it was 4 at IDB, two in each corporate names, and they were labeled New York bank accounts for sure. And we're not disputing that. But the relationship with New York is merely incidental under the case law. Again, the damages were suffered in Mexico. And of course, as Your Honors point out, this Bahamian action was and still is already addressing the underlying fundamental issue in this litigation, whether pursuant to Bahamian law, the individual plaintiffs and the corporations, the individual plaintiffs have any ownership interest in these Bahamian corporations and thus a legitimate claim to those assets, which Mr. Rosenthal has appropriately caused to be transferred out of his company bank accounts into his personal account. The ultimate question of Bahamian law is currently the subject of the Bahamian litigation, and all of the parties, with the exception of nominal party IDB, is participating.
Any witnesses? Are there any witnesses who would be individuals who would be witnesses to these transactions or witnesses to this action in New York?
No, Your Honor. No, Your Honor. The transaction was transacted by a banker.
Go ahead. You're
I'm sorry?
freezing.
Can you hear me, Your Honor?
Could you start again with whatever
Yeah,
you
you
please?
froze a little bit.
Sure. My apologies. The other financial institutions that counsel mentions, including among others, Morgan Stanley, we issued subpoenas to those financial institutions related to issues that were having nothing to do with the money that was transferred to Mr. Rosenthal's personal bank account at IDB. These are issues. Yes.
Sorry. Counsel, what about the stipulation that was never signed that would have effectuated the transfer of the return of the assets to the corporate account?
Sure, Your Honor. I'm happy you raised that. As was pretty clear from the record, the transfer of the money back to the corporate accounts was cumbersome, to say the least.
He still has the money, right?
No, the money is back in the corporate accounts. This matters.
The money never left the bank, isn't that so?
The money is back in the corporate accounts. It took a little while because for the reasons set forth on page 13.
Counselor, Mr. Lux, in fact, the money never left the bank.
Absolutely.
Right.
It was just in another account.
Accounts.
And now it's back. It's back. The very
let's hear from your correspondent.
May it please the court. Thank you. I'll try and be brief. IDB is a New York bank. We take no issue, no position on the forum non-argument, which seems to be the overwhelming disagreement as between the other two parties. But we do say, obviously, that if IDB
But whatever happened here, you're a New York bank, but you have an office in Mexico, right?
There is a representative in Mexico, but IDB is not a national association. It's specifically a New York chartered bank. It's regulated by New York, and it's chartered by New York.
But no one came into a New York office to deal with these transactions, or did they?
Not that I know of, and not that there's nothing either way on that actually in the record. I don't know the answer to that.
And what about the books and records and witnesses? Are they just based in New York or what?
To the extent that there is discovery, yes, IDB's office is in New York. I would argue that's potentially less relevant these days because depositions and documents are all can all be easily done virtually, but IDB is certainly located in New York. Its office is in New York. There are IDB reps that are not in New York, but the main IDB office is in New York, and then all of the executives are in New York. But I think more importantly here, IDB is really being dragged into the middle of a pretty nasty divorce between two very wealthy people. At the end of the day, IDB is just holds an account. The account mostly has securities. It's actually, I believe, mostly Apple stock. It's risen in value greatly. All of that stock is now back in corporate accounts. So the case is moot, but even before the case against IDB became moot, there really was never a case because, one, IDB's governing documents prohibit these types of claims. Two, there was never any loss. The money was always at IDB Bank. It was frozen. It fluctuated with the market. It rose in value. It's interesting that the appellant says in their papers, well, really the value of the case should be the value of these securities at a reasonable time after they were moved, plus interest on that. I would submit to you that that's still actually significantly less than the assets are worth today based on the rise up in the Apple and other related stocks under COVID. So the truth is, if that's the money they want, we could probably sell the stocks. There'd be plenty of money left over and we could distribute that to everybody else. But really the case was a non-starter under the account agreements, which on the one hand, they say are explicitly govern that the case must be in New York, but on the other hand, don't prohibit the claims. So I think it's hard to kind of have it both ways. And they really, IDB has no role in any of this. No money has been taken, and all of the money is now back in the corporate accounts. And most importantly, whatever it is that Mr. Grinberg did or didn't do, and that the plaintiffs take issue with, was permitted. They were signatories on this account. They had every right Mr. Grinberg had every right to move that money. IDB it does not have a duty to guard against Mr. Grinberg's misappropriation. Even if they told an IDB rep, hey, please don't do that, their recourse should have been to go and get a court order. And if they'd gotten a court order, when they got their court order, IDB complied with it. They can't simply say we told IDB because actually the account agreements also explicitly say that even if you tell us there's a dispute, we have no obligation to freeze the money. So really, this is something that's been created by the parties. It's their dispute. There's no real loss here. I think there are other reasons why they want to maintain this case in New York, but IDB shouldn't be a part of
Any other questions for counsel? Thank you. Mr. Petroselli?
Yes, thank you. Very briefly, one, we don't believe there is a requirement that Mr. Grinberg actually needed to come into New York personally in order to transact business. As a corporate signatory to these two corporations, he opened up New York bank accounts, and at least in the context of jurisdictional considerations, the Court of Appeals in the Banco Obriziano case that we cite into our papers noted that a New York bank account was, quote, closely related to plaintiff's claims to recover $15 million because it was the very account through which defendant effectuated the transaction at issue. That's precisely what happened here. Second, with respect to the documents, it is not the case that the documents that were sought as a result of the two Southern District actions by Mr. Grinberg are unrelated to this case. Quite the opposite. They sought discovery from IDB. They sought discovery of bank account statements for the corporate accounts that are underlying this litigation. We also believe that ultimately that's not really relevant because, again, in the same Banco Obriziano case, the Court of Appeals noted that broad allegations that Bahamian law will apply or that witnesses and documents are located outside of New York are not sufficient to overcome plaintiff's choice of forum. This case has a very direct connection to New York. Finally, the representation that all of the assets has been transferred back to the accounts is not correct. We have a very significant dispute with Mr. Grinberg as to whether he did in fact direct IDB to transfer all of the assets that he embezzled back to the account. It's hard to say because he did the process on his own, which I think raises its own issues in the sense of he, being the corporate looter, should not be the one to decide which assets get to come back. He froze plaintiffs out of that process. But in any event, based on the limited information that we have, we believe that there's anywhere from $2 to $4 million missing from what he had transferred out versus what came back in. And those are very serious questions that we believe need to be adjudicated by a New York court. Unless there are any other further questions, I'll rest on our papers.
Thank you. Thank you all. People versus Reid.
Good afternoon. May it please the court, my name is Stephen Fireman. I represent the appellant. The people's case was based primarily upon Brown's testimony of the shooting. Considering Brown's testimony was contradicted by the victim, Mr. Lopez's testimony, to such an extent, it appears they were describing two totally different shootings. The people's case was not supported by sufficient evidence. At the very least, the jury's verdict was against the weight of the evidence. Brown testified that he was outside of the deli. He was watching Appellant and Mr. Lopez. There was then approximately 10.
So there is surveillance video, is there not, which places the defendant in the deli in and about the time of the shooting. Am I right about that?
That's correct, Your Honor.
Mm-hmm.
So Brown was outside.
But does that video also show him show the defendant taking something from his vest pocket?
Well, yes. Well, basically, Brown was describing the surveillance video of the deli. He was outside looking inside to the deli. A Mr. Wolfe, who he identified, was standing at the door blocking his view. He indicated Mr. Wolfe was talking to the appellant, who was a number of feet inside the deli. Brown indicated that he had difficulty hearing the conversation since he was outside, not inside the deli. When he believed that he heard Wolfe say words to the effect, "You pulled on me," he thought that he immediately assumed that the object that the appellant took out of his pocket was a gun. As the people indicated on page, I think, 29 in their brief, it was impossible to see exactly what the object was. It was a dark object. I would believe, or I think you could look at it and say it could be a number of different types of objects, such as a phone, a cell phone.
I'm sorry, this is Justice Weber. I'm confused. I thought that I read that Brown saw the defendant point an object at the complainant, pointed towards his abdomen, and then the complainant went down because
No,
he had
that
been
was
shot. Didn't Brown testify to that?
well. That was the shooting outside. Brown was basically outside, and he said that that the appellant and Mr. Lopez were having a conversation, and then he saw the appellant took an object out of his pocket and shot Mr. Lopez 3 or 4 times, and he fell to the ground.
Right.
However, Lopez testified that when he left the deli, he only saw 2 individuals outside. Neither of them was the appellant. As he continued to walk away from the deli, there was a number of shots that came from behind him, causing him to fall to the ground.
So I'm sorry. So your argument is that although Brown testifies that he sees the defendant, the appellant, take out an object pointed at the complainant, and then the complainant is shot and goes down, and the surveillance video shows an object being taken out and the complainant being shot, your argument is that there's insufficient evidence to show that the appellant engaged in this conduct?
Well, no, I apologize. I'm confused about your question. There was 2 separate. There was no video outside. The only video was inside the deli.
But wasn't there video surveillance of an object being taken out by the defendant appellant?
Yes, that was inside. That was inside the deli. But that you really couldn't tell exactly what the object was, as the people have conceded. However, the people.
I understand that they're not saying that you could identify it as a gun, but Lopez was shot.
Lopez, that's correct.
Also,
Lopez was shot.
There is also evidence, is there not, of jailhouse calls?
There was a number of phone calls that.
So what do those phone calls reflect?
Well, they just reflect that the appellant was in jail waiting for trial, and as it was difficult to actually understand some of the conversations. But then it
the tenor of those conversations are not supportive of the people's position that the defendant was the shooter?
Well, my interpretation of the conversation was simply that he was asking people questions about what was the people's case.
And at some point, isn't there some discussion about Brown?
There was a discussion where he indicated that from his attorney, I believe, that there was information that
Mr. Feynman, let me put the question a different way. The telephone calls, certainly I'm not going to say constitute an admission, but the telephone calls are consistent with the people's theory of the case. So when you tell us this is against the weight of the evidence or legally insufficient, it's a very long trip for us to take.
And counsel, aren't we talking about not the phone calls to his attorney, but the phone calls with his girlfriend?
There was 1 or 2, right. There was a number of phone calls. 1 or 2 of them was with his girlfriend. That's correct.
Any other questions for Mr. Feynman? Thank you. You have time in response. Let's hear from the respondent.
May it please the court, Alice Wiseman, appearing on behalf of the people. Your Honors, I think this case is so far from being, this is one of the stronger cases taken altogether in terms of the evidence that will be before the court. It's certainly very far from being a question of legal sufficiency or against the weight of the evidence. You have, first of all, an eyewitness who was reluctant to get involved, but did get involved when the police approached him, who had no bone to pick that we know of with the defendant, who can be seen on the video.
I just want to check if I'm recalling correctly. Mr. Brown did have a criminal record, am I right?
He did, Your Honor, but it was not an extensive one. 20 years, I think, earlier, he had a very serious conviction, although he got probation for it, for assaulting his wife. Since then, he had a couple of, I think, disorderly conduct convictions, and one for smoking marijuana, I think a fair beat. And nothing in the previous 5 years. And again, he had no discernible motive. There was no advantage to him of identifying the defendant. And I want to point out, and we discussed this in our brief, that surveillance video corroborates everything that could be corroborated in Brown's testimony, except that it does not show what happens once the 2 parties, the victim and the defendant, move out of sight outside. But we know Brown is right there. We know Brown is where he said.
We know the defendant is right there from the video.
We know the defendant.
There's no question about that. We know that Lopez was shot. We know that Brown identifies defendant as the shooter. And then we have the jailhouse calls, which are consistent with your theory of the case.
Yes, Your Honor. And I would also point out that those jailhouse calls show that the defendant was quite confident that the victim, Lopez, was not going to identify him. And Lopez, in fact, refused to cooperate with the investigation into who shot him from the moment that the police talked to him in the hospital, right after he's had his surgery. And he wouldn't talk to the police afterwards. The only reason he testified is because he was arrested on something else and we brought him in. So the fact that he's saying, I don't know who shot me, I was shot from behind, obviously that the jury could take that for what it was, which was, even aside from his degree of intoxication, he obviously didn't want, for whatever reason, to identify the man who had just shot him.
Now, your adversary also makes reference in the brief to the fact that the gun that was allegedly used to shoot the Mr. Lopez was used, I guess, weeks later, was involved in a shooting weeks later after this incident, which your adversary argues goes to the issue as to whether the defendant was in fact the shooter.
Yes, I mean, obviously at the point that happened, the defendant was already incarcerated. He could not have done that shooting. But just as what happened on this day, which I think was 2 months after the shooting, there were shots fired and the shooter then discarded the gun and ran away, and the police found the gun. It's simply not inconsistent with this defendant, who not only, unlike that shooter, shot someone and knew that he hit him and that he might die, that he should have either discarded the gun right after the shooting or passed it off to someone else when he was arrested. I mean, there's simply no reason why the fact that somebody else has that gun later, however they got it, is in no way inconsistent with the defendant doing the shooting.
Any other questions for counsel? Mr. Feynman?
Thank you.
Yeah, I just want to address a comment. I'm sorry, I missed a portion of Judge Weber's comments. For some reason, my computer froze. But in any case, with regards to the gun that was found outside about five weeks after the shooting in the same neighborhood, the DNA was of a Mr. Shaku, and Brown testified that he had seen Mr. Shaku a couple times in the deli previously. That sort of increased the possibility that he could possibly have been involved in the shooting involving Lopez. If the court has no other questions, I'll just rest on my brief.
Thank you. Thank you both.
Thank you.
Cabrera versus 65 Park West Realty.
Good afternoon, Your Honors. This is Steve Score for the appellant Israel Cabrera. The plaintiff established a prima facie case under Labor Law 240 by showing that he fell from an unsecured ladder while he was painting at a construction site. This was fully corroborated by the co-worker who was only 10 feet away at the time. The defendants in the corporal law raised two main arguments. The first, that when the super who was not at the building when the accident happened came to the scene 20 minutes later, that she said the ladder was standing up. She had no opinion or no knowledge one way or the other if someone had moved it before. This court in Kebby versus Greenpoint Goldman in 2017 rejected this exact same scenario in the context of a 241 case, saying as there was no evidence other than the ladder was standing up and no evidence whether someone had moved it.
In the claim in this case that a can of paint had spilled out?
Well, sure. I mean, he was painting. So the super said she didn't know whether or not there was paint on the floor immediately after the accident. She said, I don't think so, because I don't think I would have put my sweater under the catastrophically injured plaintiff's head. As I said in my brief, other than making her a fairly terrible person, it doesn't give anything evidentiary one way or another. The defendants had an expert who said, when I came to the scene 2 years later, the super told me a few things. Now, these things were both hearsay and the exact opposite of what she said during her own testimony. So the first thing that he said the super told him was that when she got there, there was a paint can on the ladder.
You know, it seems like if a can of paint had spilled out in a boiler room, there certainly would be some indication one way or another what happened to it.
Well, I mean, the only evidence of anything is their expert who said 2 years later I came and I didn't see any paint, and she told me that the floor had not been altered, which was one, as I said, it was pure hearsay. And the second thing is she testified in contradiction to that of course I cleaned the floor in the 2 years since the accident happened. I put the site to the record. So the only evidence or anyone saying that there would have been paint, there should have been paint later, is an expert basing it completely on a hearsay statement contrary to the person who he's talking to. And the person he's talking about is the super who testified. She said, I didn't see whether or not there was a paint can on the ladder when I got there. She further said, I don't know if there was paint on the floor after the accident or not. I don't know. And she further said, well, in the 2 years between the accident and when the expert got to the scene, I cleaned the floor.
Did not the expert also testify as to his examination of the ladder in question and stated that it was good overall, safe overall condition, hinges, locks, provided the proper locking mechanism?
Oh, sure. He went even further and said that an A-frame ladder is self-securing, so it didn't need to be self-secured. So pretty much this court has said in every labor law decision they've ever had come down in 240 that it doesn't matter whether or not the ladder is defective. The question is, did it provide the worker with a safe place to work? Here the worker said he was working on it. There's no testimony that he did anything improper and that the ladder slipped out from under him. Under every
Aren't there two witnesses who say that the A-frame ladder was on the ground and paint was on the ground where the plaintiff was lying? In other words, Mr. Morales, his co-worker, and then Mr. Martinez Garcia, who testified that he knew both the plaintiff and the building superintendent, and he responded to the scene.
Yes. So the plaintiff, so the co-worker who was in the room said, I came there. The plaintiff was lying on the ground. I picked up the ladder and moved it so people could get into the room. Therefore, our case is even stronger than Kev, because he said, and the super agreed that the ladder had fallen at the entrance to the room. He said, I moved it out of the way. So the fact that the ladder her testimony was standing was later. But here, some paint had, there was testimony that the paint was painting and that he'd fallen, but she testified that she had cleaned the floor.
Counselor, thank you. Thank you. Respondent? Is the respondent present?
Muted. He's muted.
Apologies, Your Honor. I thought I unmuted while plaintiff was speaking. My name is Seth Weinberg. I represent the defendant respondent. With regard to the paint on the floor, Mr. Morales testified a quarter bucket of yellow paint fell to the floor.
Counsel, let's back up a little bit. We have an unsecured ladder and we have a witness who says he was right there when it happened.
He didn't see the fall.
He didn't see the fall. He was 10 feet away. He heard the bang, immediately turned around and saw his coworker on the floor.
Correct.
What?
But as this court has held, not every fall from a ladder is 240. And if he fell and lost his balance off the ladder, that's not a 240.
But he said it wasn't locking properly.
And the expert reviewed the ladder and says it locks fine. And plaintiff testified. At one point, the ladder worked fine. I didn't have any complaints. Then one arm was loose. Then he testified, well, maybe both arms were loose. Then I can't identify which arm was loose. So there's even a question of fact as to whether it was locking properly or not.
So how would you say that the ladder was secured?
If the ladder's arms were locked in place and it was not wobbling, that is secure. There is no
was it nailed into the ground or secured into the ground, or was there any sort of other mechanism?
No, there was no other mechanism.
Or was there anybody spotting for him?
No, there was nobody spotting for him. But the question of fact remains, did the ladder fall? Because if a quarter bucket of paint fell on the floor and was never cleaned, and the superintendent said she dusted in the years following the accident, not I cleaned up a quarter bucket of yellow paint all over the cement floor whether this gentleman was lying in or didn't. A jury could find that a ladder with a bucket of paint on it doesn't fall and not leave any paint on the floor.
Do we know what color the floor was?
Cement, plain cement.
Cement, it was unpainted, you're saying?
I believe so. It's just,
paint, you know, cement is often painted.
I don't recall any testimony about a color of the cement. But the point being, this expert is entitled to rely on the interviews of witnesses. Any expert is allowed to rely on outside the record materials, provided it's generally accepted in the practice. And here, asking the person who is in control of the room, was any work done to alter this room in the last 2 years?
What in your view is the rule of when a fall from a ladder is not covered by 241?
So if a plaintiff just slips and loses their balance off the ladder, if the ladder itself doesn't move or doesn't fail, that's not a 240 case. And that's why, for example, in Campos, this court held that the mere fact plaintiff was off the ladder and on the ground, if there's a question of fact as to how he fell.
And what about the fact that the ladder was also found on the floor?
Well, again, you have to assume for that to happen, this for a jury to decide that it happened and the quarter bucket of yellow paint didn't drip any paint anywhere. That would be for that to work. Otherwise, the ladder didn't fall and the ladder didn't move because, according to Mr. Morales, a quarter bucket of paint fell. And according to the super, I never cleaned the floor. No one worked on the floor short of dusting it. And there's no paint on the floor. So that's the question.
Despite we have plaintiff's testimony that he fell from the ladder, we have two individuals who found him on the floor and the ladder on the floor. But because apparently there's no indication of any spilt paint via your expert, then therefore he would not be entitled to relief under partial summary judgment under 241?
Correct. That's a question of fact. The jury would have to determine, and the jury may very well say these three gentlemen are more credible than the facts presented by defendants.
But for testimony as to the spilled paint because of your expert weeks or years later.
Well, it's not solely because of my expert weeks or years later. It is because the superintendent indicated anything that was done after the fall was dusting the floor.
I just, under 240, I know we have cases that say where the ladder is unsecured. You had no one securing the ladder. 240 requires that you have that there be a safety device. This ladder was there it was not bolted in. And that's why in a number of these cases, we find that there's a worker holding the ladder to be sure. There was none of that there. I don't understand how a bucket of paint or not changes that you did not have any security to the ladder.
Because it presupposes, Your Honor, that the ladder itself moved. If plaintiff just tripped over his own feet on the way down,
he should have had a security device to prevent that.
A ladder, and as our expert, a ladder is a safety device, a proper safety device. As our
ladder is not a safety device.
Your Honor, this court has held, many courts have held, that a ladder is a safety device unless it wobbles, moves, or collapses. At that point, it's not a safety device.
There, it's an unsecured. We've had that it is not secured. That is exact.
Well, Your Honor, that generally talks to ladders that are closed and leaned against the wall.
No, I don't think so.
Anyhow, counselors, thank you both. Thank you. Pavone versus Samadi.
May it please the court, Jacqueline Pisano on behalf of the defendant appellants, Dr. Samadi and his PC. Your honors, there are two issues that I would like to address. The first issue deals with general business law, section 349, and the second issue deals with punitive damages. With respect to the first issue, plaintiff has failed to allege that Dr. Samadi's conduct was consumer-oriented. Notably, in the Court of Appeals case, Carlin versus IVF America, the court acknowledged that a doctor's treatment of a patient does not typically involve consumer-oriented conduct and that this statute will not supplant traditional medical malpractice actions. There is a crucial distinction between Carlin and this case. The claims in Carlin were not limited to information provided by the defendants to plaintiffs during the course of their medical treatment at the program. Instead, the plaintiffs in Carlin allege that IVF America's consumer-oriented misrepresentations deceptively lured them before they started any course of treatment. Additionally, in Carlin,
isn't there consumer-oriented representation by way of the internet publicity given to Dr. Samadi, who was touted as the world's best prostate surgeon, both by the hospital and by himself on their separate and various websites? A
subjective statement that Dr. Samadi is the best urologic surgeon in the world is it amounts to puffery and cannot be actionable under consumer protection statute because the Court of Appeals in Carlin adopted a definition for what is materially misleading, and that has to do with a consumer that is acting reasonably under the circumstances.
And wasn't the advertising, or could the advertising of Dr. Samadi's abilities, could that not be seen as an inducement to sign up for a surgery by him, only to find out afterwards that he didn't have anything to do with your surgery, but rather an unsupervised resident did the whole thing while he was someplace else?
So the lower court has already dismissed a claim for false advertising. I think that you might be referring to Dr. Samadi's website, where it contains information about himself. It contains information about the procedures that he performs. And this is, a website is not considered an advertisement. It's a passive medium where a consumer can find information about him. And also the conduct.
Let's turn your attention to the punitive damages before your time runs out. Is this a case of such, the allegations, I'll stress that, it's a pleading motion. The allegations of the conduct of the conduct alleged is so outrageous. After all, you advertise to get people in to be operated by Dr. Samadi, and then what happens is that there are operations going on by people being operated on by residents who aren't even supervised by Dr. Samadi, and that's before we even get to the billing issues.
Right, so the punitive damages claim, punitive damages are alleged with respect to the intentional torts. In this case, it was the fraud cause of action, the assault, and the prima facie tort causes of action. According to the record, pages 1263 and 1264, punitive damages are not sought with respect to the medical malpractice cause of action. However, even if the court does find that punitive damages survive the dismissal of the intentional tort claims, this is not a case of unlicensed the unlicensed practice of dentistry or the performance of unauthorized abortions. Here, a plaintiff is alleging that Dr. Samadi is at the hospital and that he is in another operating room, and this is a teaching hospital. And so the punitive, these facts.
Let me stop you. What does that mean if someone is being operated on by a resident who isn't even supervised by Dr. Samadi?
Well, those allegations don't rise to the level of intending to inflict harm on a patient or malicious conduct.
So we all know what a teaching hospital is. And we all know that residents work under supervision because that's how they learn to do surgeries. But here you have unsupervised residents performing surgeries on a surgery upon a patient who thought that they were Dr. Samadi, because that's what he signed up for on the form. So why wouldn't punitive damages be appropriate here, where there's so many misrepresentations, apparent misrepresentation?
The informed consent form actually that's executed acknowledges that Dr. Samadi would be assisted by his associates and/or possible residents And that is.
So counsel, at what point was he assisted by the residents if he wasn't there?
Even if you take that allegation as true, this does not rise to the level of malice or wanton negligence or gross recklessness that he manifested evil motives to harm.
You don't have to be evil, do you, to be completely reckless? He knew he was supposed to be in there and he wasn't in there. Is that not completely reckless?
Well, he
was just plain stupid. Is that not completely reckless? Anyway, I don't have any questions.
Anyhow, you have time in response. Let's hear from Lenox Hill.
May it please the court, my name is Nicholas Tam and I represent the appellant Lenox Hill as well as Northwell Health. I just want to make one clear distinction. The hospital's role in this case is one step removed from the surgeon, Dr. Samadi. To the extent that there were
Counsel, how, if this is a teaching hospital with residents who are working at the hospital, who are supposed to be performing, I would imagine, surgeries under supervision, where are you going with your argument here?
The case of Lowry is instructive and it requires complicity. And what that means is the hospital as the institution has to be complicit in or ratify any outrageous conduct.
I thought that the evidence or what was submitted thus far is that Lenox Hill was aware of the fact that Dr. Samadi, you ratified you approved his bills, you knew that the bills were falsified, you knew that he was also billing for simultaneous surgeries as well. You took no actions concerning the improper billing. So why would that not make you complicit? You knew this was going on apparently based upon his billing, because he's billing stating that he's performing the surgeries and we know he was not performing the surgeries. He's also billing for simultaneous surgeries. So why does that not show your complicity?
So Justice Weber, I'd like to address that with two things. First of all, there's no indication in the complaint that the hospital directed or instructed Dr. Samadi's practice in any way. He retained.
No, I'm not saying that I'm saying that you acquiesced in it and that you accepted the billing. I'm not saying that you told him, do this. I'm asking whether or not the evidence shows that you at least acquiesced in it because you approved the bills.
The allegation of acquiescence is conclusory and lacks any particularity in the complaint.
And this is getting paid twice for one surgery is not dispositive here.
It's not dispositive. Actually, plaintiff himself concedes in the complaint that the American Medical Association, the American College for Surgeons, and the Center for Medicare Services guidelines state that a physician is permitted to bill for a surgery where there's a resident assisting him. As my
counsel, we go back to the same question. How can you be assisted by a person when you're not together in the same surgical suite? You're not in the same operating room. Where's the assistance?
Well, the way it was set up, and this is according to the complaint, there's no discovery at this point, is that Dr. Samadi was down the hall in another operating room, and he would return for the critical or key portions of the surgery, which allowed him to bill for the surgery that the resident was primarily taking. And this is a stone's throw. This is orders of magnitude apart from the cases cited by the plaintiff. Figueroa versus Flatbush involved unauthorized abortions. Garber versus Lynn involved unlicensed dentistry.
So you're saying that the hospital and the doctor can bill for a surgery performed by someone who's not there?
Not entirely not there. In this case, Dr. Samadi was available at all times. There is indications that
available down the hall. Available.
He returned for the critical or key portions, which would permit him under the CMS guidelines.
And this is a teaching hospital? This is the practice of the teaching hospital?
It's the practice of Dr. Samadi, which is what I was leading off with, which is the law requires the hospital to be complicit and to ratify.
Isn't some of what you're saying, this is your defense, but they were talking about a pleading motion after all, and as to the pleading, you may be able to show, well, yes, he was there, he was supervising, he was there to help, and maybe that is a defense. But at this point, the allegations as we have them, correct me if I'm wrong, are that someone else was doing the surgery.
No, there's only speculative and conclusory statements that the hospital, and I'd like to note that the plaintiff's complaint names all these people from the administration, including the CEO, CFO, and everyone else that they knew and were complicit in this practice. There's no evidence of that. Every statement is conclusory. Just to turn to the general business law allegation, the preoperative consultations were between Dr. Samadi and his patient. Again, the hospital is one step removed from those discussions. The hospital is not involved in any of those discussions. So to the extent that there was any misrepresentation about who the surgeon would be, the hospital was not involved, and this claim should be dismissed as to the hospital. Okay. Furthermore,
thank you. Respondent.
May it please the court. My name is Joseph Laddie, and I represent the plaintiff's respondents in this matter. This case, Your Honors, is about patients' rights to know and patients' rights to choose when it comes to their medical treatment, and what remedies are available when those rights are egregiously violated. Patients have a right to be truthfully told about who is performing their operation. Patients have a right to choose who will perform surgery on them. Patients should have all the remedies available to them under the law, including the consumer protection laws like General Business Law 349, and punitive damages when those rights are egregiously violated. The decision and order of the court below should be affirmed in its entirety. And as you know, the court properly denied, or we submit the court properly denied the defendant's motions to dismiss the plaintiff's punitive damages claims, and the court properly granted plaintiff's cross motion to add claims under General Business Law Section 349. First, to address some of the defendant's arguments, punitive damages claims were pled with respect to the medical malpractice cause of action, along with the original intentional tort claims in this case. It's apparent from the plain language of the pleadings. The second cause of action in the amended complaints seeks punitive damages for intentional, willful, and purposeful conduct of the defendants. And that implicates much of the allegations of the medical malpractice claims here in this action, here in this case. The defendants falsely represented to patients that Dr. Samadi would personally perform their surgery. They were misled about the identity of the person who was actually going to perform the surgery, who was an unsupervised resident. They used these unsupervised residents to perform surgery on patients in OR 21 without the patient's knowledge or valid consent. And they presented deliberately misleading consent forms to patients that falsely identified Samadi as the surgeon performing the operation, and omitting the identity of the resident who was also designated as the assistant surgeon on the operative reports, who would actually be performing the surgery. They further concealed that Samadi wasn't present for, as we allege, the critical and key portions of these surgeries, and for what's called the entire viewing portion of the surgery, where the time from when the scope is actually inserted into the patient to the time from when it's withdrawn, by placing patients under medically unnecessary general anesthesia. And in furtherance of this concealment, they falsified medical records and in particular the operative report and other portions.
Counselor, your adversary states that although this is a pleading motion, which we acknowledge, that these allegations are simply conclusory.
Well, the allegations are the allegations of the pleadings. They're done with particularity and detail. I don't believe that they're conclusory at all. I believe that they're very specific, and they particularly state the ways in which patients were misled, and they particularly detail the fraudulent motive underlying the medical treatment at issue in this case. So,
Any other questions for counsel? Thank you.
thank you. Do you want me to continue?
No, we'll let, right. There are no more questions from the panel, so let's hear from Appellant Samadi. Ms. Fasano.
Briefly, Your Honors, the conduct that is the subject of the Consumer Protection Statute is a preoperative discussion between Dr. Samadi and his patient during the course of medical treatment and information that Dr. Samadi relayed to Mr. Ross, which is that he would perform the entirety of his surgery. These allegations fall under public health law and medical malpractice, a claim for lack of informed consent and medical malpractice. And this conduct that is complained of is not consumer oriented. The reason that it was considered consumer oriented in the Carlin case is because there was multimedia dissemination of false and misleading information. That is not alleged here. The surgery that Dr. Samadi performed, the surgery that is at issue, is a TURP procedure. On Dr. Samadi's website, he does not make a representation that he will perform the entirety of the surgery. There is no false or misleading information that Mr. Ross relied on outside of what was said to him during the course of medical treatment, which needs to be litigated under a claim for lack of informed consent.
Thank you. Actually, I did have a question for plaintiff's counsel. I know we finished with him, but
please,
very quickly, what does the punitive damage claim attach to? Because you have eliminated the fraud, right?
Yes, yes, Your Honor, that's true.
So what is it attaching to?
It is attaching here to the medical malpractice claim. That's my understanding from the ruling of Judge Madden in the court below. And the punitive damages were pled with regard to the medical malpractice.
The fraud is gone, the assault is gone.
Yes, and we conceded that in the court below, that we conceded that.
So it's your contention that the punitive damages claim can attach just to the medical malpractice?
Yes, Your Honor, that's absolutely correct. And that.
Thank you.
Yes.
Let's hear from counsel for Lenox Hill.
Your Honor, just 2 quick points. First of all, the Spinoza case is instructive. It says that pecuniary motives, such as doing something for economic gain, is insufficient and cannot sustain a punitive damages claim. In fact, the Spinoza court goes as far as to say that, as far as the court's research goes, punitive damages has never been upheld for a medical malpractice case. This case should be no different. Second of all, the plaintiff has not addressed the point of how Dr. Samadi's actions flow to the hospital. And I just want to stress that one more time, because this practice is permitted under the American Medical Association's guidelines.
Counsel, the residents don't belong to Dr. Samadi, don't they? Aren't they supplied by the hospital? Isn't it a teaching hospital, which therefore has residents who are working there and doing whatever it is that they do in order to become full-fledged doctors?
Yes, they do.
So why are you saying there's no nexus?
Because there's no nexus between the actual performance of the surgery to the C-suite level, CEO, CFO, upper administration that's required under Lowry's complicity rule, which is why the liability for punitive damage does not flow from the surgery to the hospital. Thank you very much.
Thank you. Thank you all. Thank you. Altman versus Salem Media.
Yes, Your Honor. William Sipser for the appellant. Good afternoon, Your Honors. This is a case of a severe sexual harassment and assault under the New York City human rights law. The issue in this case regards an arbitration agreement. The arbitration agreement, the critical language in this arbitration agreement says this agreement to arbitrate shall be specifically enforceable under the prevailing arbitration laws in the state where the venue is located, which is New York State. Upon the filing of this case, New York State law specifically prohibited the arbitration of sexual harassment claims. So the critical issue here, there's two issues here. One,
counsel, there's no
yes.
there's no retroactivity to CPLR 7515BI, right? It's effective after July 11th, 2018, and the conduct, the alleged conduct occurred before then. Am I wrong or?
No, that's correct, but there are two issues responding to that. One is there are two provisions in that provision. One says that no new contracts will be entered into with that provision, but then there's a second provision that says any contracts that are existing are null and void. There would be no reason to have both provisions in unless that was the case. But there's a second argument here. The arbitration agreement has to be enforced as written. The Supreme Court of the United States has said that in Volt. In Volt, they said under the Federal Arbitration Act, even if there are restrictions on arbitration, you have to enforce them if the parties have agreed to it, which is what happens here. And the operative language in this in this arbitration agreement says, the agreement to arbitrate shall be specifically enforceable under the prevailing arbitration laws in the case. The dictionary definition of prevail is current. So it's the current laws that apply, not the laws that apply when the agreement was signed. It would lead to an absurd result. If you had an agreement that was from 20 years ago, a 20-year-old statute would apply. It's not what the language says. And by the way, the reality is it's a fiction that Ms. Altman wrote this agreement with the employer. Everybody knows that. I understand that the agreements are enforced, but the reality is it was written by the defendants. That's their language. That has to be enforced. It's the prevailing arbitration law, which is
Counsel,
the time of the filing
your
of this
argument
case.
is that if in the agreement says by the prevailing arbitration laws, however, the prevailing arbitration laws themselves state that they are not applicable to contracts that were entered into on or before, that the contract between the parties as to the arbitration clause takes precedent over the law itself?
No, the law does not say that. The law has two provisions in it.
7515 says only contracts agreed to by the parties on or after the effective date of this section.
No, but that's only one part of the statute. The second part of the statute says mandatory arbitration clause is null and void. That's a separate provision. It's a separate provision. It's in three.
Counsel, there's no indication. Counsel, there's no indication that that clause has retroactive effect, especially given the language that this is after. I mean, I looked at the legislative history. It's effective after the section is applicable after the effective date of this section, parentheses, effective July 11th, 2018. So you're asking us to go beyond what the statute says?
No, I'm asking you to apply the statute. The second provision, there would be no reason to have the second provision if the first provision applied. It says you can't have any new contracts that have this provision. The second provision says a mandatory arbitration. The provisions of such prohibited clause is null and void. So it's also the legislature is saying two things here. Otherwise, you wouldn't need the second clause. They're saying two things.
Thank you. Respondent.
You're muted. You're muted, Mr. Stephen.
Apologies. My adversary's original sin in his argument here is one, he does not contest that there was a valid arbitration agreement that would cover the claims in this case, and that the Federal Arbitration Act applies. This is repeated throughout our papers. His original sin is that he places the emphasis on what he describes as the operative clause here and ignores that the arbitration agreement specifically states that the arbitration will be conducted in accordance with the rules of the American Arbitration Association. The issue on appeal is whether or not Judge Kalish's decision was correct in saying that, therefore, the decision about whether or not this is an arbitrable dispute under CPLR 7515 is to be decided by the arbitrator. This position is that the court took is confirmed by several decisions of this panel that we've cited in our papers: Life Receivables versus Goshawk, Smith, Barney, Shearson, Zacharou versus Minios, Appellant has articulated no basis why that would be incorrect. Instead, urges that the language he cited is the only language that matters, rather than reading the arbitration agreement as a whole and interpreting it in accordance with the intent of the parties at the time. I would also add that with respect to CPLR 7515, the appellant has argued in their papers that it was in effect at the time of the termination. That's false. The appellant was terminated in March of 2018, and the statute was signed by Governor Cuomo in April of 2018 and did not take effect until July 11th of 2018.
Thank you, Counselor. Thank you. Mr. Sipser?
Yes, just to address the point about the American Arbitration Association, that is not what the Court of Appeals.
Before you say anything,
yes.
I would just note that 7515 was amended in 2019, and the amendments were made effective October 11th, 2019, and yet there was no retroactivity accorded along the lines of what you're saying.
Well, the case was not filed it was filed in January of 2019. So it's our position that the prevailing, under their own language, the prevailing arbitration law at that time, when that issue then was brought up, the prevailing arbitration law was, and by the way, there's still the same language, there is retroactivity. On the second provision, there's retroactivity. It does not talk about, there would be no reason to have a mandatory, the clause null and void if you can't have it in there. It means if there's that any clauses that are already there, they're null and void. But on the issue about the American Arbitration Association, if I may, Your Honor, because this is an important issue, the Court of Appeals has specifically said that in Diamond Waterproofing versus 55 Liberty Owners, 4 New York 3rd, 247, it's in both of our papers, it says where an arbitration provision states New York law will govern both the agreement and its enforcement, which is exactly the provision I talked about, then the questions of arbitrability go to the court, not an arbitrator. And Justice Friedman, Justice Renwick, you both signed off on decisions that said exactly that. In Volpe versus Interpublic, which is 118 Appellate Division 3rd, 482. This is the exact language that was said. The language in the employment agreement between the parties provides that New York law governs the agreement and its enforcement, which is, by the way, exactly here. Thus, as the motion court determined, the question of waiver of arbitration is properly decided by the court, not an arbitrator citing to the Diamond case. Therefore, by the Court of Appeals, this issue had to be decided by a court.
Thank you. Thank you both.
Thank you very much.
Thank you, Your Honor.
League of Women Voters versus New York State Board of Elections.
May it please the court. Alex DeLisi from Latham & Watkins for the appellants. This case is about what the Court of Appeals has called the foremost of all political rights, the right to vote. It's a case about a law that unnecessarily disenfranchises constitutionally qualified New Yorkers. The only relief that appellants seek is for the boards of elections to count the ballots of all constitutionally qualified New Yorkers who registered to vote before the 10-day deadline set in the New York State Constitution. That relief will require only that the board.
Why shouldn't the relief that you're seeking here not have been sought from the legislature? After all, the legislature only recently amended laws covering this situation in 2019, and why wasn't there advocacy made to the New York State legislature? If this is something that should change, why wasn't this included as part of that package in 2019?
Your Honor is correct that there were legislative enactments that have made voting easier, including but those
including early voting. I mean, you're seeing the legislature seeking to act to expand voting rights. I mean, is this something which the courts should make a determination on, or the legislature, which must have considered this issue, one would assume, in 2019 when they made other amendments? Isn't that the place for this relief?
Respectfully, Your Honor, the court here has an important role to play in applying the law, and the law here that should have been applied is strict scrutiny analysis. The legislative enactments that have been enacted have made voting easier, but save for pre-registration, none of the legislative enactments have made registration easier.
What if the law said you have 10 days, that you must register 10 days? Could you come in and say that requires consideration under strict scrutiny too?
Well, if it was 10, is Your Honor's question just to clarify 10 days before the 10 days?
No, I want to know where you draw the line that we have to apply strict scrutiny here. I mean, because yes, 25 days is not an insignificant amount of time, but it's also not an amount of time which seems aimed at taking away people's right to vote. So where do you draw that line when you say we have to view this under a strict scrutiny standard?
Understood, Your Honor. Any day over the 10-day constitutional floor would disenfranchise voters. Therefore,
falls under strict scrutiny.
Falls under strict scrutiny under longstanding Court of Appeals precedent. And again, the reason is
although the legislature, by having adopted this 25-day rule, seems to have been operating under the view that the Board of Elections needed something like that in order to handle new registrations.
Of course, you're exactly right, Your Honor, but legislative discretion in this area isn't unbounded, and the court has an important role to play in that. Legislation that disenfranchises must be held to strict scrutiny and serve a compelling state interest in the least restrictive means possible, and that's not been met here and can't be met here.
But by your reasoning, 10 days would constitute disenfranchisement too.
10 days above the 10, currently the New York State.
Even at 10 days, I mean, because you point to all these states which allow registration on the day of voting, on election day. So why isn't any number not acceptable?
To clarify,
why isn't any number of days not acceptable?
To clarify, Your Honor, the New York State Constitution sets a floor, and that's right. 10 days. So that's definitionally
anything above that, by your view, requires strict scrutiny
because it disenfranchises voters, and therefore, and that's based on Article 1, Section 1 of the New York State Constitution, and again, case law has grown out of that. And the cases cited by respondents don't compel a different result. None of the cases cited by the respondents involved New York laws that directly infringed upon the right to vote, like the cutoff law does here.
Thank you. Respondent.
Thank you. May it please the court, Philip Levitz for the respondent, State Board of Elections. Supreme Court did not abuse its discretion in declining to grant a preliminary injunction of New York's voter registration deadline for at least two independent reasons. First, plaintiffs are not likely.
So the Constitution sets this 10-day limit. What justifies going beyond the 10 days?
The Constitution sets a floor, and the expectation of the legislature was that there would be other laws made to deal with registration as needed. That language is actually in the same provision of the Constitution. As Your Honor was getting at, the legislature took that into consideration, acted on it, and created this 25-day deadline, which is completely in the mainstream of every state that has these deadlines. The reason for this deadline is manyfold. Basically, the legislature needs time to do what's necessary to get voters registered in advance of the election. That includes verifying the identity of those who wish to register to vote, verifying that they satisfy the constitutional qualifications to vote, providing those voters with information about
Your
where,
adversary
how to vote.
says, counsel, that those validation efforts are expedited because of the advances of technology. What do you say in return?
The legislature has not made a determination that technology at this point is sufficient to have a deadline later than the 25 days. And there are very good reasons for that. One is that
among other things, if they were to make that determination, they would also have to decide to fund it.
Absolutely, Your Honor. And one of the reasons, I mean, there are a variety of reasons why the technology is not sufficient at this point. One is that not every local board of elections has electronic voter rolls. Many polling places don't have internet access to have access to those voter rolls electronically. And in any case, the board requires backup printed copies of the voter rolls. So the rolls have to be complete in advance of the start of voting. And by the way, the start of voting is not election day, as Your Honor was getting at. It's early voting, which at this point is just 2 days away. That truncates the 25-day period down to 15 days, given the changes that the legislature is already making in this area. So to get back to what I was talking about, plaintiffs are not likely to succeed on the merits because they have not overcome.
One question, please.
Yeah.
So if we now have early voting starting October 24th, is the deadline changed not only for this election, but for all forthcoming elections? Does it become 15 days? Or does it remain?
Yes.
Does it remain at 25 days?
It's now effectively 15 days because early voting is now in the future always going to be an option. So basically what's happened is the 25-day deadline has gotten cut to 15 days before the start of early voting because early voting starts 10 days before election day in any election.
So the difference between your position and your adversary's position is 5 days, in effect?
No, so it's a different 15 days, right? So there are 15 days between 10 days before the election and 25 days before the election. Our position is the legislature set a deadline of that 25 days before the election, which becomes effective. The period is truncated. You understand? Yeah.
Yes, now I understand. Thank you.
Yeah. Okay. So the first way in which we should prevail in this case is no likelihood of success on the merits. Separately and independently, the balance of the equities weighs strongly against altering longstanding election rules on the eve of an election. And we are just 2 days away, as I said, from the start of early voting, and only 12 days away from the start from actual election day. So let me go into a little bit more detail on all this. First, on the likelihood of success, plaintiffs did not prove by the clearest evidence, as they must, in order for an injunction altering the status quo, as plaintiffs are seeking here, that New York's 25-day registration deadline is unconstitutional. New York's Constitution expressly authorizes the legislature to enact registration laws, and the legislature's exercise of that constitutional authority to enact the registration deadline at issue here advances the state's compelling interest in the integrity of elections. We talked about that a bit. Let me also make sure I respond to plaintiff's point about strict scrutiny. Plaintiffs err in seeking application of strict scrutiny in this case to the registration deadline at issue here. Both New York state courts and federal courts have uniformly held that registration deadlines do not impose a severe enough burden on the right to vote to merit strict scrutiny. Plaintiffs don't cite a single case applying strict scrutiny to a voter registration deadline, and we have cited many cases, both from this court, the Moody case, from the U.S. Supreme Court, from courts around the country, saying strict scrutiny does not apply to registration deadlines because they're not sufficiently severe.
Councilor, thank you. Any other questions for now? Appellant, Mr. DeLisi.
Thank you, Your Honor. 2 points. First, all the state board would need to do is expand existing procedures. There's nobody is contesting the state's power to enact laws that restrict the franchise for reasons that further a compelling state interest. The reason why the state board can't meet that standard here, and certainly why the court below didn't grapple with this issue in any sense, is that the state interest here cannot justify the mass disenfranchisement given that the existing procedures are sufficient. They just need to be expanded for 15 days, and that would obliterate the mass disenfranchisement of 30,000 New Yorkers that happen every single election cycle.
Would you agree that they have been expanded de facto by the enactment of this early voting law?
Respectfully, Your Honor, no, I wouldn't agree with that, because there's still, anybody who registers today would not be able to go to the polls on Saturday when early registration votes, when early voting starts, and be able to cast a ballot. And that's the relief that we're seeking, because if I go to the poll and I'm not in the tablet, the iPad poll book, I cast a provisional ballot. The state board has a duty after the election to check my registration status. All we're asking them to do is count the votes of folks who registered instead of up to 25 days before, up to 10 days before. They're already checking the registration status of those folks. All we're asking them to do is expand the existing procedures. And if I may just address the point, because counsel for respondents brought up Moody and this idea that there's case law that addresses this situation, which is just simply not true. None of the case law, again, actually prevented eligible voters from participating in an election. In Moody, the case was addressing the validity of party enrollment deadlines. The law there didn't actually disenfranchise anyone from participating in a general election. And the party enrollment deadlines raise all sorts of different state interests, such as First Amendment freedom of association interest. It's completely understandable that type of law would be subject to a rational basis type review, whereas a law that absolutely directly disenfranchises should be held to strict scrutiny. I mean, the Court of Appeals put it in no uncertain terms in Rosenstock against Scarage, quote, where a statute directly infringes upon the fundamental right to vote, the appropriate standard of review is to strictly scrutinize the legislation, end quote.
Thank you. Thank you. Thank you both. This concludes oral arguments for today. Court is adjourned.